Any day after Monday.
The petitioner assails.
ডিভিশন থাকতে থাকে প্রত্যেকটা ডিস্ট্রিক্টে।
ও অফিসার বলে দেখি কোন সাপ্লাই সেটা অফিসাররা করে।
I am for the petitioner, my lord. This is my affidavit of service. The crux of the matter in this writ petition, my lord, I am a purchaser of a property through a e-auction. I have on 14 March 2014, I have purchased a property from the central bank, Shalkia branch, in verge of 18 lakhs 11,000 rupees. Till date, the possession has not been given to me. I inquired to the bank that when you have given me the possession, the bank informed me verbally that there is a status quo. The borrower approached DRT and there is a status quo. The status quo order, my lord, kindly come to page number 16 of my lord's brief.
Page 16.
16.
Yes.
What that is the thing that learned counsel for surface application submits that the property has been sold during the substance of status quo. They have approached the DRT in February. DRT has passed an order against the bank that there will be a status quo. In between that, the bank has already sold out the property. Now we are standing in 2026. In 12 years.
Where is the sale notice?
Sale notice I have not annexed, but sale certificate.
You have to show, sale certificate will not do. You have to show the sale notice, what was indicated in the sale notice.
Yes.
It's to be seen. If the sale notice indicates that there was an essay pending at that point of time and you have purchased it, then in that case, You'll have to wait for the essay to be disposed of.
My lord, I couldn't
If
understand.
the sale notice indicates that there was a surfacey application pending
Hmm.
and you have entered into the transaction with the bank despite pendency of the surfacey application,
Hmm.
then you'll have to wait the for till the disposal of the surfacey
Surface
application.
application that I know.
So that is why you have to show what the conditions of the sale were.
Sale
What were the
certificate হবে না,
conditions
sale
of this?
notice টা লাগবে। Sale
Not sale certificate, sale
sale
notice.
notice, sale notice right now I have not sale
Bring the
notice.
sale notice and who is appearing for the bank.
Bank, I have served the bank, but
You serve another notice because it has been upgraded at your instance.
yes, well, yes, my lord. Even my lord, I show one order to my lord, that DRT has ordered the petitioners to implead me as a party respondent. I have nothing issue. I don't want the property right now. I want my money back. Nothing else.
All of that depends on the sale notice. If you can't show from the sale notice what the terms and conditions are, you cannot expect an order right now. Show the sale notice first.
My lord, kindly fix it up a date. I will bring up the sale notice. Sale notice ka lagbe eta.
Learned new motion এই রাখবেন affidavit লিখে একদম উপরে লিখে দিন affidavit of service filed in court today is taken on record.
Sale notice ka aanta hoga.
হ্যাঁ কি করবে
Item number 7 and 10 मतलब same identical issue मतलब yesterday my lord pass the order मतलब analogous hearing 7 and 10 मतलब 8 मतलब I am for the petitioner
7 and 10 not 8
7 and 10 मतलब yesterday मतलब pass the order for same issue मतलब
দেখি 7 and 10 দুটোই দেখিয়ে দিন
7 and 10
yes
मतलब another lead petitioner मतलब file the petitioner मतलब to give the electric supply मतलब for submersible pump मतलब already मतलब in my land मतलब submersible pump मतलब the honorable justice मतलब Bishwanath Samadar मतलब pass the order मतलब that 200 meters मतलब distance maintained मतलब can you look at the page 54 that one submersible pump to another submersible pump it is maintained
54 of which petition
मतलब my petition मतलब item number 7 मतलब
page 54 yes
हाँ page 54 मतलब main portion मतलब there cannot be any manner of doubt whatsoever that for the purpose of construction of a mini deep tube well there is a requirement of a minimum distance of 200 meters to be maintained between one mini tube well and another. If construction of mini tube well is being made without adhering to the 200 meters distance norms, then such construction is required to be immediately stopped. And Malad, this is the order, and Malad, one government order, Malad, that government order passed, Malad, page 56, 46, Malad, main portion, government order, page 46. Page 46, serial number 5, Malad.
page
Tube
46
well with submersible pump for irrigation purpose, Malad. take permission from the district level office of West Bengal State Groundwater
Page
Resource Development.
46, where are you reading?
Page 46, that is.
Yes.
Yes. Take permission from the district level office of West Bengal State Groundwater Resource Development Authority, geologist of the state.
Where are you reading? Page 46, take permission. Where is it written? I did not find it.
At the top, my lord.
At the top,
Serial number 5.
serial number 5,
46.
page 46. My repetition.
I don't find any take permission sort of a thing.
Number Page 47, this is a mistake. Yes, page 47.
Yes, page 47.
Page 47, serial number 5. Fuel with submersible pump for irrigation purpose. Take permission from the district level office of West Bengal State Government Water Resource Development Authority, State Water Irrigation Directorate, Government of West Bengal for digging of any fuel or well from which water is extracted, which the help
Yes, I have got it. Yes, what do you want to say? That this
of
has
not
been-
maintain the 200 meters. That is the my pair is the
WACDC.
ACDC.
My lord.
Yes, Mr. Bandopadhyay.
Well, I appear on my lord appear in item number 10. This is the my lord the
It's
Yes,
the
it
same
is-
thing both
yes,
ways.
petition file.
His contention is that the two tube wells don't have a distance of 200 meters in between. So if the tube well of the private respondent in the first writ petition is within the distance of 200 meters, then in that case, electricity connection cannot be granted to such submersible pump.
Well, as per my instruction, there is no such well, this is a safe zone and well, there is no restriction of well, 200 meters. We don't know. We don't have any well, restriction well, to maintaining the 200-meter distance between two tubes.
Yes.
The notification shown is of the well, Panchayat department.
Yes.
That
The notification that has been referred,
annexed,
that
that
is
is referred to.
to the
that
Gram
is-
Panchayat. My lord, if your lordship kindly turns to page 40.
Page 40.
40.
This is one of the department of
Just,
Panchayat
just a
and
moment,
Development.
Yes, my
Mr. Bandopadhyay. Now
Yes,
let me
ma'am.
hear it. You said you don't have instructions.
It appears at page 40. This is a department. This has been,
Page 40,
yes, my lord. In my writ
it
petition,
may be 41,
might be.
41. Yeah.
Yes. ma'am. So therefore, this is not binding upon, because if your lordship kindly turns to page 47 once, if the statute says if the concerned area comes within the safe zone,
And what
no
will you do
permission.
with this order at page 54?
Page 54, my lord, this issue has been decided afterwards by a number of coordinate bench. My lord, if your lordship kindly permit me to hand over the documents wherein it has been held that if the concerned area comes within the safe zone, the 200 meters restriction is not a restriction, my lord. Not kindly permit
This is
me.
not a safe zone,
My lord, that has
What
to
will
be.
be for the authorities to
Not-
say? You don't say that safe zone or not safe zone. You are not the authority.
This is one in 2016 order. Give me. This is also.
নাম্বারগুলো বলো তো শুধু।
দিয়ে দিচ্ছি একটা করে, তোমার জন্য এনেছি একটা।
Yes, Mr. Bandopadhyay, what is your instruction as regards safe zone so that I can take that on record?
Another
With respect to
8
safe
to-
zone, my lord, there is no restriction of maintaining all at once.
This area falls within safe
Yes,
zone.
yes,
or
yes.
Not where is the?
Yes,
If you
safe
don't
zone.
have any instruction, how will I proceed?
Safe zone, my lord.
How will I? On your oral submission, I will not proceed.
My lord,
My lord,
There
that-
is something on record.
For this issue, I have filed one application on DNS section 163, and police submitted the report. It is very much clear. Kindly look at the
Police
page
report.
40. Page 40,
Hello, before that.
page 40. I have filed the DNS section.
to you.
Page 40. It may be page 40, madam. This is not a safe.
40 of item 7.
Respected sir, kindly look at the after 8 lines.
পুলিশ বলবে
It transpired that a dispute exists between a petitioner and the OP member regarding installation of mini deep tube oil electric connection over the land situated at Mouja, Ghatampur, jail long such and such PS Dadpur. The petitioner stated that he has been operating a mini deep tube oil over his land after obtaining necessary permission from the competent authority. This is mine. And has been using the same for irrigation purpose for considerable period. It further transpired that the OP member has taken steps for installation of another mini deep tube oil in close proximity to the petitioner's existing installation. This is
What turns on this? On this, it doesn't turn out that it is not a safe zone.
this is the close.
May I?
Your
Well, according to the petitioner, he is running a submersible pump. Let him show that his submersible pump does not come within the purview of safe zone or not. He is running a safe.
there is no
So
prohibition.
in that event,
There is no prohibition in sinking a tube well in a safe zone. The prohibition is that two tube wells cannot be sunk simultaneously within a distance of 200 meters.
My lord,
So
well,
if his tube well has already been sunk, yours is subsequent to his, then your tube well will
But
not be
if
allowed. If it is an unsafe zone, your tube well will not be allowed to be sunk within a distance of 200
my
meters.
lord,
So for that, he is not required to show
my
how
lord,
he is
but
running.
even if the zone does not come within the purview of safe zone, he is to take permission from the authority.
That is different. The case is now on you. You have to show because he has already got.
Yes,
So there is a presumption that official
Or that
works are
state can-
done in
state
the
can
correct
issue-
manner. So as still such time that you challenge it, his
No, I am not on that. My lord, this is
so
my
therefore
contention.
in this writ petition he cannot be worse off. It is
No,
his
no.
writ petition. I will not disconnect his supply in his writ petition. You have to show that it is in the safe zone. If
Brother,
you show that it is in the safe
My
zone,
lord, state is to appraise, my lord, whether this come within the purview of safe zone or not. I have
he is
read
appealing
the
for the
I'm
geologist.
appealing for the state in item number 10, my lord. As of now, my lord, no instructions has come to me. Lordship kindly keep regarding the safe zone part, my lord. I will seek
That is
instruction.
the
if your
only
lordship-
thing. That is the only thing which is required. How
I will,
long will you
I will
take
come
for
back with
this?
instructions, my lord.
Malad, I have a document, Malad, this is the Malad, report, Malad, 90 pages.
File a report. We shall
Well,
see.
Malad, wherein Malad, the list of zones Malad have been prescribed, there wherein Malad, this Dadpur is under safe.
দুটো রিট পিটিশনে একসঙ্গে লিখবে।
My lord, I am for the
My lord, in
petition.
this item number 8, my lord, I beseech my lord to decide the issue of maintainability at first, my lord, subject to my lord sanction, my lord.
I can't hear you.
Micro cholche na.
ঠিক আছে? My lord, the last occasion, your lordship could not take up the matter. Matter was taken up, but could not hear the matter, my lord, due to absence of the bank.
Was taken up. You could not satisfy service. Your service was not completed. That is the order.
My lord, that is true, my lord.
Yes.
My lord, I have again served, my lord, and the file the affidavit of service, my lord. I have again served, my lord, file the affidavit of service.
My lord, on similar issue,
Let me hear him. Yes, what is your problem?
My problem is that, my lord, I took loan from the bank, my lord. Thereafter, my lord, they issued notice under section under 13(2) notice, my lord. I have given reply. My lord, they have subsequently, my lord, they have issued notice under section 14(2), my lord. 14(2) has already lapsed, my lord. Matter is pending before the DRT. My lord, another thing, my lord, I have submitted an application.
Why have you come here?
My lord, yes, my lord, I have submitted an application for one-time settlement that your lordship can consider, my lord. That is, my lord, at page
One-time
24.
settlement I cannot direct. I cannot direct the bank.
But
to
your
enter
lordship
into a
can,
compromise.
my lord, your lordship can direct for consideration, my lord, of my one-time representation.
Consideration, they will be free. There can be no mandate. They may not.
My lord,
consider-
I am not paying before lordship for a mandatory order, my lord. Your lordship kindly only.
Mr. Saha, you consider his
no, my lord,
proposal.
kindly considers, my lord, his conduct, my lord. He
Arey,
made,
if you-
my lord, he made a
Mr.
proposal.
Saha, instead of fighting,
No, no, no.
he has made a representation. If you don't
We have
find it,
considered. We have
reject
considered.
it.
We have told him. Okay, he told that I will pay rupees 15 lakh.
Mr. Saha, you are again entering into merits. He has made a representation. You are not happy. Reject it. Finished.
We have allowed it, but still he failed. He failed to pay in terms of that.
Where is the
that is-
question of further consideration? They have considered.
My lord, your
Yeah,
lordship
now
kindly
we
see,
have
my lord, this representation has not been considered. 17/7/2026.
Which document?
17/7/2026, my lord.
Repeated representation may not, my lord, be
My
permitted.
lord, 17/7/2020.
Representation was made, my lord, on the next page, my lord, to see, my lord, that
এই
we have
17
considered
সাথে
rejected.
consider
We have
হয়েছে?
allowed.
No, if 17/7 he has made something different, why would you not consider it? Is he not entitled to consideration also? If he has made a
My lord, he is
representation,
trying to what have happened after making this representation.
again we are
No,
entering
my
into merits. He has made a representation that I will pay say 50,000. You are disagreeable with that, you have rejected it. Good, you are entitled to that. Subsequently, if he makes another representation saying that I want to pay 1 lakh, would you not consider that?
But
You should say that
my
no,
lord,
1 lakh
my
will
lord, my
also
lord,
not.
we may consider this,
Then why are you
but
arguing on
it
this?
may not be a tactics to buy time, my lord.
There is no question of buy time. Court is not granting him time. Court
My
is
lord.
not staying your SARFAESI action.
My lord.
Court is not saying that you will have to stop.
My
But if he makes a representation saying that I want to pay this much, should he not? Should that also not be considered?
But 15 lakhs, my lord, I am ready and willing to pay, my lord. 15 lakhs, my lord. That
Earlier,
was-
he also made this 15 lakh
If it is
representation.
the same prayer, then it will not be allowed.
Same prayer, my lord. We have
15
we have
lakhs-
considered, we allowed him, he did
No,
not
then
pay.
he has a point. If you have not raised the threshold that wanted to pay some 1 year back, today also you remain at the same position.
that
And you
was-
want, there can be no review of the representation.
My lord, not, this is not the review, my lord.
Of course it is. If the same amount is there, it is review only. What else is there? What is the change? If we have said that yes,
My
we
lord,
have
you'll-
enhanced the offer, then in that
My
case,
lord, then I can, my lord, enhance the
then
limit,
I
my
will
lord.
not interfere.
My lord, your lordship kindly consider, my lord. Your lordship, my lord, at least, my lord, your lordship kindly, my lord, your lordship kindly.
Then he is right. You are unnecessarily then harassing the bank also, and this petition is also unnecessary. You should have made a different representation. I would have understood. You at the first.
My lord, this is another representation, my lord.
Another representation with the same amount doesn't make any difference.
My lord, at the, my lord, when the touch made, my lord, I have some financial crisis, my lord. Your lordship kindly make another
That I cannot
opportunity.
enter into.
My lord, I am praying for another opportunity.
I cannot
My lord, I am praying for another.
If you pay in any case, they will not. go.
Automatically it will
How
go.
can they accept payment and then proceed for sale? They can't do that. That goes without saying. Cholun.
Grateful, my lord.
Nine minutes, I am for the petition. My lord, in this case, my lord, the petitioner applied for a submersible pump in 2009. My lord, wherein, my lord, the load was, my lord, given when the quotation was issued by the WPACL, my lord, the transformer load was given, my lord, 10 horsepower. My lord, I lodged complaint the very next day that this should not be 10 horsepower. Actually, I am, my lord, installed a 5 horsepower submersible pump. Even then, my lord, it continues. My lord, thereafter, my lord, provisional assessment notice was served upon me on 4/4/2025, taking into consideration of load of 8.4 kVA. My lord. Thereafter, final assessment order was issued. My lord, I preferred an appeal. In the final assessment order, they have finally assessed that rupees 3,03,607 has to be paid in terms of the final assessment. I preferred an appeal, my lord. My lord, if your lordship kindly takes pen to the order passed by the my lord, passed in appeal, my lord, which is at page, my lord, 25. Last two paragraph, page 25. On hearing of oral submission examining the written submitted documents, I come to conclusion that the assessment against pilferage of electricity for illegal use may be achieved by as assessed by the concerned station manager and assessing officer in the final assessment bill. Accordingly, it is hereby ordered that the revised energy bill for pilfer stroke loss of electricity is to be preferred by the concerned station manager and assessing officer in terms of under section 126 of the Electricity Act 2003 and corresponding clauses of WBRC. My lord, in terms of this, my lord, order, my lord, they, my lord, issued a my lord, revisional bill. My lord, kindly see page 20C once.
Page
27. Sorry, 27. My lord, in terms of the appellate order, my lord, this bill has been raised. Final assessment bill has been assessed rupees 3,03,607, which was actually in the final assessment bill. They have not revised. My lord, same bill has been, my lord, raised. My lord, this is under challenge before your lordship. My lord, I have 2 points before your lordship. My lord, first of all, my lord, the load which has been calculated, my lord, in 8.46 my lord, kVA. But my lord, so far the my lord, submersible pump is concerned, which is my lord, running only my lord, 5 horsepower, and the load, the transformer load in the quotation, your lordship will find in the quotation, my lord, the load has been given 10 horsepower. Maximum load of a 5 horsepower submersible pump, my lord, can be given, my lord, maximum, my lord, 6.5 my lord, kVA. My lord, that was the submission made on behalf of the my lord, the appellant before the my lord, appellate authority, my lord. Now, that has not taken into consideration. Although, my lord, the appellate order, my lord, speaks, my lord, some my lord, revisional my lord, clause has been given by the assessing officer, my lord, but that has not been done. Exactly show, my lord, what they have, my lord, assessed in final assessment, my lord, they have given in the revisional assessment bill, my lord, same, my lord, amount has been given, my lord.
Yes, because the appellate authority says the same. Appellate authority says the same thing is to be done.
My lord,
Well, this is admitted.
If you see the second paragraph which you just now quoted,
my lord,
you see in as assessed by the
Yes.
but
but
the same thing.
but next part, my lord, next part also, my lord,
Next
therefore, my
will
lord,
have
it
to
is,
be read
it
along
was,
with the first part.
my lord, it was not required in that even, my lord. That is why, my lord, my lord,
No, next.
appellate authority, my lord,
To approach the appellate authority, seek clarification. I cannot clarify the appellate authority's order. If you want to get it clarified, I cannot clarify this.
my lord, this part has been, my lord, it's okay, my lord, but my lord, the second part, my lord, also,
No.
my lord, it has been directed to, my lord, the
No,
assessing
Milord,
officer, my lord,
I clear to your lordship.
revise the
Second part
appellate
means,
assessment.
Milord, they are the engineers, your lordship, no, they are not the legally expertise. No, second part means the appellate authority is of the opinion the bill should be, fresh bill should be raised.
Yes,
Not
because
phrase,
Yes,
not phrase bill.
yes.
device bill means
Phrase
fresh, of
bill.
course, he's right in that sense, because.
They are not the
because
legally.
Some consideration has been given, that's why, my lord,
Oh,
you have
this is,
directed to,
That's
my
some
lord.
consideration, that's some consideration neither you can infer nor I can infer. You will have to go before the appellate authority for clarification if you want that, because I will not be able to put words into the appellate authority's order.
Very well, but I will approach before the appellate, kindly.
Sir, he admitted final assessment,
That,
filing objection along with his written statement before the hearing authority.
If he wants to approach, let him
No, no,
approach,
let him approach. I don't know.
because I will not be able to infer. My prima facie But the appellate authority also, Mr. Kole, asked them to write.
Yes,
properly.
because
What
below
kind
the
of order?
English is.
This-
You know,
we have seen other orders.
yes, yes,
also.
yes. I-
This is very confusing.
Yes, yes. That I have already seen.
Tell them that write
Yes.
it properly, maintain
Actually-
one stand.
Yes, there is no clear. That's grateful.
This creates unnecessary difficulty.
Unnecessary. I had a talk with the applicant.
May I please the lordship? This is a video service. Now, the short question before a lordship is that, my lord, whether the occupier or the tenant is entitled to a hearing in the, my lord, section 14 proceedings before the, my lord, the CMA, my lord.
Settle it.
My lord, settle, my lord, 2012, my lord, then, my lord, the law evolves, my lord, then, my lord, the law changes in 2016 and 19. I show from the document that the, my lord, I am a prior tenant.
Ram Tarle,
Ram Lalit.
Balkushan Ram Tarle.
2019, my lord. My lord, I am a prior tenant. I am not an incumbent, my lord. If I am a prior
For
tenant,
DRT, section 17(1)(a).
but yes, my lord. 17(1)(a), I prefer 17(1)(a) prior to this, my lord, section 14. Prior to section 14. So, my lord, my cause of action will change. I have to withdraw again, my lord, I have to file then.
File an
My
interlocutory
lord,
application.
today I am before a lordship, my lord. Why I am before a lordship, my lord?
Mr. Ghosh, I cannot entertain. And you know there are several judgments.
There are, I know, my lord.
You know
See,
it
my
better.
lord, 2016, I have 2016, my lord. So Supreme Court says, my lord, that, my lord, the prior or posted and prior tenant, I have the right posted. Then, my
Yes,
2009,
but right, you have a right to assert before the DRT, not before the High Court.
my lord,
And
I am
not
not,
before the section
I am
14.
I am not before a lordship to, my lord, assert my documents, annex the documents, my lord. Today, I am not, my lord. My lord, my lord, there is CMM code or, my lord, the DRT code. My lord, I do not have the
CMM court does not have authority to hear.
authority to,
No
my lord, recall,
adjudicatory power.
authority to recall, my lord. This is an administrative order. This is an administrative order. So that is why I am before lordship, not in the, my lord, the civil division. So, my lord, in the administrative order, my lord, he has no power to recall, my lord. So, my lord, I am before your lordship, my lord, only on the point, my lord, to give me a hearing to prove my case.
To whom?
Nothing.
You cannot, he cannot give a hearing.
My lord,
If
in the
I-
meantime,
if I allow you to go before the section 14 authority for a hearing, I will be transforming it into an adjudicatory process, which the Honorable Supreme Court has said it is not. It is a non-adjudicatory process,
yes,
ministerial.
yes, it's a ministerial job.
Therefore, he cannot grant you a
Ministerial
hearing.
job. Now, my lord, today, my lord, I have problem, my lord. Only section 14 order has been passed. So, my lord, if I went to the,
Challenge
my
it
lord,
before the DRT, get
my
a
lord,
stay.
your lordship knows it's a matter of common knowledge. DRT is not alternative remedy is the one at DRT. There is no problem, but there is no efficaciousness in the one at DRT.
That I cannot.
But there is no my
That is
argument is, my lord, DRT is not an
there is a
efficacious
statutory
remedy
forum.
before your lordship.
It is functional. It is not
It
that
is
the
functional,
DRTs are
but it
shut.
is not efficacious.
Approach them.
My right,
It is
my right will be, my lord, prejudice, my lord, if my lord, physical possession has been taken from me. So, my lord, that
You
part
have-
can be.
The order is of 26th of February
But
2026.
I don't know. I don't know. I know later on. I know when the police came. I know.
Writ petition on 7th of August 2026. We are on 17th.
Yes,
In these 10 days, you could have very well approached DRT, got an order of stay if you
But
had
then
a very
only
good case.
one order, my lord. Only one order, my lord. My lord, in the meantime, for the 10 days or 15 days, my lord, for
Mr.
15
Ghosh,
days, my lord, kindly protect me.
This also has been harshly commented by the
In one in other cases, not in surface matters.
No. In February 2026, saying that if you are turning the party back to the alternative statutory forum, you cannot pass a stay in between.
Yes, my lord. Protection order cannot be given. That man.
Relying on 52 Supreme Court.
Today, my lord, I will be non-suited. If the physical position has been
You
taken,
have
I
your
will be
opportunity,
non-suited.
You go before the DRT.
So, my lord, then, my lord, kindly fix a time within which, my lord, DRT has to.
You don't have any application before.
But
the
I have the
DRT, time for
application.
what?
I have the application before the DRT. I have already filed. Before
Where is
this
that?
section 14, my lord, kindly take, my lord. Kindly take page, my lord. Page 58.
Page 58.
58. Whether my lord, the prayer is not against the section 14. My lord, section 14, my lord, I came to know later on.
So you file your IA in this and
Yes, my lord. Kindly, my lord, fix within which, my lord, DRT has to be, my lord.
this writ petition.
Item number 12, my lord, I'm appearing for the respondent to UCO Bank. Item number 12.
Herein, none appears for the petitioner. No accommodation is prayed for. List this matter under the heading for dismissal on August 26, 2026.
My lord.
UCO Bank is represented.
My lord.
Next.
My lord, this is my affidavit of service, my lord. I have served everyone, and just the last track report I have downloaded it today. Rest 3 of them served on that affidavit. The last one, the track report was not coming out. That's why. Well, a very simple matter. Section 14 order granted by the DM, pursuant to which bank has taken possession. Possession was with the bank. Thereafter, the borrower one day at around 1:30 a.m. Went in, barged in, beaten up the security guard and forcefully took over the possession. Criminal case lodged, police is investigating. Today I am for reinforcement of my order. This is my simpliciter prayer, and I am relying upon the judgment very recently passed by my lord in WPA number 20235, following our coordinate bench judgment of our court in the PNB Housing Finance. These are the 2 judgments I am relying upon. A similar order may be passed wherein the DM may be directed to depute an officer subordinate for restoration of the possession.
My lord, as per their complaint, my lord, already, my lord, police have taken steps.
Yes, I am not disputing that. That is pursuant to the criminal matter.
Section 14, repossession.
Yes, possession has already been given. Thereafter, my lord, again.
Yes, but again, if somebody has barged in, the DM has to act again and pass an order directing the police to take possession.
Lord,
Lord, the only one submission. Kindly see the page 21.
Page
21 of the
page 21.
This is by 13-2 notice.
Yes.
Yes.
13-2 notice dated 10th October 2024. A notice addressed to Mrs. Samantu Jewelers Company. The to Samir Samantu. My lord, my respectful submission, the notice itself served upon the dead persons. As because the
Let him go to DRT. Let him go to DRT.
1 minute. Lord, the person died on 2nd February 2018. Entire proceeding has been against the dead persons. No legal years has been impleted in the proceedings for section 14, and even that in the read application also no proceeding, no person is included. And apart from that, my lord, so far my information.
Who is dead?
There the legal years.
Number 2 is dead.
Two legal aids.
Samir Samantu is the Makalisi. They have stated Samir Samantu is the guarantor. Samar Samantu is a guarantor. Samir Samantu only deceased person. Well, kindly see they do 2.
Yes, but through legal heirs they have written.
Through legal heirs, who are the legal heirs? They have not.
So that information he has to provide.
They don't know the names of the legal heirs. Prima facie, it does not appear.
Even that, my lord, they know that the person died.
They know that the person has died.
So my respectful submission, entire proceeding has been initiated death person against the proceedings. Apart from that, so far my information, my lord, a DRT application has been filed challenging that. My lord, I turn lordship's attention.
Yes, you take this point before DRT.
Yes, that is true.
Take this point before DRT, but you cannot. You cannot just barge in and take possession. How can you barge in and take possession?
No, my lord, who has given position? Who has taken the position?
The police has
they have not
possession.
the party.
My lord, kindly see the police complaint.
Apart from that, my lord, if you also kindly see, they have lodged a complaint. Under the 41 notice has been complied with. My lord, the notice
that will take its own course, but there are orders of court where the person, whoever he is, if he has taken possession in defiance of the order of the Section 14 authority, the Section 14 authority will implement its order. You go and challenge it, get it set aside.
My submission.
You cannot barge in.
No, my submission should be recorded. Since the my lord, since the my lord in the deed application, the legal years has not been implemented party. And see. And my lord, the entire proceeding also, my lord, even section 14 proceed back, that my submission should be recorded.
Yes. And what about the heirs of you know the heirs of the
He is representing one of the heirs, respondent number 5.
No, I am not the legal heirs.
So who is he?
I am a guarantor. You have stated in my notice.
Shamal Samanto is related to Samir
Related,
Samanto. How?
How?
Brother,
How is he related to Shamin?
brother, not the legal heirs. And
When was possession taken?
My lord, the possession was initially taken on 9th of March. 9th of March 2026. Order is of 9th of January. My lord would see the order at page 42 and the certificate of possession and at page 52.
Also 2006, or the person died 2018.
2026. What he is submitting. My lord, page 52 is the Panchnama and certificate of possession is at page 62.
Panchanama is the, no legal heirs is included.
And my lord would find the signature of S. Shamanto at every page bottom while the Panchnama was prepared.
Samantha is a guarantor.
And thereafter, my lord, the
Who was the owner of the property?
just give me a moment.
Somit Samantha.
Somesh Shamanto.
Somit Samantha is dead.
Then it becomes a little difficult, Mr.
No, my lord, it will not. Why I say so? Because just my lord, just give me one moment, my lord.
You are enforcing security interest in the property.
Because my lord, my section 14 order is against the property, not against any person. Now, my lord, no.
Has to
This
be
dead
with the-
person, but
It has
just
to be in respect of the owner.
so the proceeding has been initiated. The proceeding has been initiated under the SURFACE Act. When the notice, we didn't have the information of the legal heirs. They admittedly did
Then
not provide.
You then satisfy that how.
So
could
that
the
is a
court-
subject matter. That is a sub.
Once you seek implementation of an order before court, the High Court is justified in going into the legality of that order. Otherwise, I cannot direct implementation of an order which is per se illegal. You have to.
But
then cross the
what
threshold.
I am challenging, my lord, kindly appreciate this thing. What I am challenging.
Mr.
He is-
Guha, you are challenging the inaction of the district magistrate.
No. I'm not at all challenging the inaction. My lord, kindly appreciate what I am challenging today, or why I am before my lord. A section 14 order has been passed. That order is not under challenge either before this Honorable High Court or before the Debt Recovery Tribunal.
Once it is brought to the notice of the court that the order is a nullity since it has been passed against a dead person, you have to cross the prima facie threshold that the order is not a nullity because it is passed against either a right person or the right to claim the property still exists by way of a section 14 order being passed in your favor. You just cannot say that, no, I will ignore this, all of this.
No, I'm not saying I've ignored this. What my 13.2 says.
The
What
order
my-
may not have been challenged. You know the law.
Yes.
That if an order is a nullity, it can be
Per se, my
challenged
lord,
even-
there is our coordinate bench judgment.
Maybe
In
it is on a
submit
different-
matter, there is our coordinate bench judgment
That
which
even
says
if
that
it-
does
even
not
if-
make the action entirely bad.
It depends. You cannot say that if the issuance of notice itself is on a dead person.
I completely. But my lord, kindly come to the notice. It was not issued on a dead person. Kindly come at page 21. Kindly see. Who is the just 1 second, sir. Kindly come to page 21. Kindly see who is the borrower. Borrower is Messrs. Shamanto Jewelry and Company. It's a unit. Next is
Maybe then also you should have then taken steps to see that the section 14 order contains such.
yes, section 14 order contains
See,
that.
come
Now,
to
my
the
lord,
section
kindly
14
comes to
order.
section 14 order.
Yes, see. Section 14 order.
Applicant has filed the present petition with affidavit. It appears.
Kindly see the lines in bold.
Yes, it appears that appeared that an application has been filed by such and such by Sotrajra against respondents.
Yes. Yes, see,
against respondent
It's not
Samanto
against
Jewelry
the
and Company, Mr. Somir Samanto
not
and
against the
Shamol
heirs.
Samanto.
Yes, so Samir Samanta is no more there. You were also aware of this. Your notice shows that the order is against Samir Samanto, which is dead person. The property is in the name of Samir Samanto, who is a dead person. How would you proceed with this?
My lord, that is the reason it was served through the legal aids.
Maybe, but
Kindly
the order is
appreciate
not
this.
on the legal heirs. See the order. That is why I'm
My
saying
lord, that does not
it's
make,
not
with
that easy.
deepest of respect, my lord, that does not make his action correct.
It does not.
He barged
It does not inspire confidence of the court to get this order implemented also at the same time.
My lord, kindly keeps the matter tomorrow. Let me come back with that coordinate bench judgment. Thereafter, my lord decides on this issue. And I'll also factually take some instruction from my client also. Kindly keeps it tomorrow. I got, my lord, what is troubling, my lord. Allow me to come back tomorrow. And if I can satisfy, otherwise, my lord may dismiss my application.
Come back on Tuesday, not tomorrow. Tomorrow there
Very
will be a
well.
lot of matters. Likhen it. As prayed for by Mr. Guho, learned advocate appearing for the
appear for the petitions. This is my affidavit of service. But the respondent is a housing finance company, my lord, registered under the National Housing Bank, my lord, Act 1987, my lord. Is a one of the category of NBFC, my lord. My lord, previously they have issued one possession notice. My lord, we have challenged that possession notice on the ground, my lord, since the secured debt amount was below 20 lakhs. But that has been stayed initially. That was, my lord, the petition was disposed of by permitting them to withdraw that possession notice, and pursuant to the direction, my lord, they have issued a fresh 13-2 notice, my lord. My grievance is, my lord, till date, my lord, although the notice of the previous proceeding has been withdrawn, but the padlock has not been removed, my lord, and my lord, the physical possession has not been, my lord, restored to the petitioner, my lord. To that, my lord, petitioner made a representation, page 26, my lord, and the fresh, my lord, the 13-2 notice has page 22 on 2nd July. There is for, my lord, the 60 days is statutory period is there, my lord, to give reply, my lord. And the last order passed by this honorable court, my lord, page 21, my lord. And the initial stay, which was interim order, was granted by this honorable court, page 19. Thereafter, the petition was ultimately disposed of, page 21, my lord, by permitting them to withdraw the liberty.
You serve the learned advocate who appears for this.
But I have served, my lord, the notice upon the office.
Since they are not appearing, serve a notice on the affidavit of service filed in court today is taken on record.
Well, a picture on the petitioner will availed 3 loans from the respondent bank. 3 loans from the respondent bank by depositing by creating mortgage in respect of the 3 properties. So for the first loan is concerned, it was squared up. After paying the
First loan is?
it was entire amount was paid and that mortgage was released. Subsequently, with respect to other 2 loans, I have initiated proceeding under the section 17 before the DAT that is pending. In the meantime, I want to settle the bank with the bank. Then I have filed one-time OTS proposal to the bank with 10% of the upfront amount. That has been utilized. Your Lordship knows that it is OTS is like offer and acceptance. When he accepted my offer, and after taking, he has not returned that amount, What they did, this by a letter, they said that you enhance the amount, OTS amount. So, I have enhanced, along with upfront amount. This time, they return back, they refused to accept my OTS proposal as well as they return that later part of the amount I have deposited under the OTS. So, my humble submission is that, when the first proposal, it is an offer and acceptance, your Lordship knows that when bank accepted it, after not utilizing my upfront amount, then bank has to adhere to that OTS scheme as per the RBI guidelines.
Well, first and foremost, the REIT is not maintainable at the very first instance. Muthoot Finance. Secondly,
I said, the matter is pending for your Lordship today.
Answer it now. He is raising that point.
Muthoot Finance, my lord, allow me. And thereafter, I will rely upon Bijnor and Arvinda.
Bijnor and
Bijnor is a different thing.
On OTS. And secondly, my lord,
that will only come when he
crosses. Cannot issue mandamus, my lord. Here, my lord, kindly consider.
How would you cross the hurdle of Federal Bank, Muthoot Finance and Shobha?
Well, first of all, my lord,
I
know that paragraph 9 is there.
Then answer that if you know it. That is the only question. Please answer that.
Yes, my lord is asking question to me. That, my lord, so far as the private bank is concerned, my lord. Now, my lord, with my lord greatest humility, I have submitted this to your Lordship. This judgment, my lord, has not considered G Teleflips, which is larger bank.
Supreme Court, sir. I will not say that what's
the larger banks, my lord.
Whatever it is, there are judgments to that effect that a Supreme Court's judgment cannot be held to be per incuriam by the High Court.
No, I'm not saying that.
That is exactly the point. Once you say that this judgment has not considered that, the meaning is only that if a judgment has been passed.
Another smaller scope is that, my lord, this judgment says only, my lord, issuing of the REIT. Now, under Article 226,
you are issuing
under Article 226, under Article 226, my lord, your Lordship power is wide enough to pass order and direction also.
No, sir.
This only confined to the REIT, my humble submission.
Yes,
kindly,
you are asking for REIT only.
May I read?
What else are you asking? You are asking for REIT only. What else are you asking for? You are asking for issuance of REIT only. What other thing are you asking for?
For order and direction, your Lordship.
Order and direction in the nature of what? In the nature of REIT only. This is REIT jurisdiction.
No, REIT kindly says Article 226.
You have come up with
Mr.
Sahara, either allow the court to complete or you complete.
Sorry.
You have come up before this court where this court is exercising REIT jurisdiction only. I am not exercising 227 civil revisional jurisdiction. I am not exercising CPC's Section 9 jurisdiction. I am not exercising Section 34 jurisdiction or Section 37 jurisdiction of the High Court under Arbitration and Conciliation Act. I am exercising 226 jurisdiction under which I can only issue writs. What else can you ask if not for writs? Any direction or order that I will be passing will be in the nature of writ. And that has to be your prayer in the writ petition also. If I have only determination for issuance of writs, and the Honorable Supreme Court has said in no uncertain terms that writ will not lie against a private entity, and that is the law. How do you expect this court to exercise this jurisdiction?
Kindly consider Article 226, my lord. It is not.
That has been considered by the Honorable Supreme Court, and law has been laid down. I cannot lay down a law different than what has been laid down by the Honorable Supreme Court.
my lord, 226, my lord, to this, my answer is that, my lord, kindly, my lord, subject to correction of your lordship, my lord. The 226, my lord, not only confined to the, my lord, issuing of the writs. It's also, my
This
lord, your
is a
lordship.
case which covers your very field. This case is governed by this case.
No, according to
cannot go-
Bijnor, my lord, I cannot ask for, my lord,
Not
mandam.
Bijnor.
No, no, I'm, my lord,
You answer this point, read
My-
paragraph 9. I'll come back in 5 minutes, read paragraph 9 and answer.
my lord.
Be gone.
It was here only. What the? Check question.
Yes,
Yes, my lord, may I come back, my lord? Tomorrow. My lord.
लिखे नहीं
Item 16.
Plan for the private respondents.
May I please, your lord?
The difficulty is, my lord, we have not received a copy of the writ petition.
My lord, the affidavit of service will speak itself.
They must have,
Both
my lord,
PSC
served upon the department.
Both CSC received and the
Regional
district
department.
engineer received. Kindly see, deliver.
If they
Deliver.
could serve it upon the legal
The
department.
stand of the CSC, my lord, is already been communicated, my lord. That, my lord, my land friend has to challenge, my lord. That's, my lord, annexure P6.
My
The
lord, it is-
entirety of the stand of the, my lord,
My lord, may I
distribution.
please, it is my case, my petition.
Sir, আমি বলছি না।
Sir, I don't.
serve a copy on him.
I have already served them, my lord.
You can't serve another copy.
At present, I have only one office copy, my lord.
Very well, he will get it photo stated.
I have to make a Xerox of the same.
Make it. You can't make it.
Yes, I shall serve. I shall serve.
How soon will you serve?
But it will, how much time will take the machine? That will be enough, my lord. I will
tell
get
me
a copy
that.
of the same. I will serve it again.
When should I keep it then?
I don't know. Copyright.
When should I keep the matter?
Well, 10 minutes after I will do it.
10 minutes, he will not be ready with instructions. I'm keeping it on Monday. Serve in the meantime.
Monday and Tuesday, I will not be there. Tomorrow, I can meet.
Serve it today, you take
Yes,
instructions,
tomorrow.
come tomorrow.
But how can the one thing subject to your lordship correction? But how CSC authority can deny the receipt of the copy, my lord?
Not denying. You have served on the department. It will take time for the department to.
This is their disability, my lord.
Very well, then on his ground, I'm adjourning it for 10 days. You come after 10 days. If that is the practice which you follow, then I'm adjourning it because
No, my
it's
lord.
taking time.
I
Be
shall serve.
reasonable.
I shall serve.
Be reasonable. Why do you want the court to be harsh
If I
unnecessarily?
had it with copy of another, I would have given it right now.
The learned
term to be established by the earlier Milord petitioner who moved the writ petition. And Milord, the villagers came forward, they objected us. Milord, they made the application, paid the amount, we have accepted it, made the survey. During survey, Milord, we did not have any objection from any quarter. But when he started, Milord, installing the pole, then Milord, parties came, some objections were raised. So, Milord, we placed this case before your lordship. In that petition, that is, Milord, 9361. 9361, and that was, Milord, the order passed by in that writ petition is also, Milord, annexed with this present writ petition, that is at page 55. 50. That was the, Milord, order, where a district magistrate also had the opportunity to examine the entire issue and, Milord, heard the parties and pass the order directing us, you go ahead, but take enough protection, see so that no causality is taking place, and Milord, electricity line may not cause any harm to anybody or anybody's property. That was the direction of the district magistrate.
Mr. Naik, this is not a transmission line.
No.
A distribution line.
Milord,
which is being drawn for the benefit of a private individual.
Lordship.
If it is crossing somebody's field, you have to take the permission of that person.
No, lordship. But here the case is, Milord, the entire PWD road is there. Milord, 11,000 kVA line is there. From there, Milord, we are drawing, Milord, 400 meter coming inside. Inside that is also, Milord, a, Milord, concrete road of going to the village. And by the side of that,
what is the problem that you are facing?
My lord, this is actually, my lord, what I am told, the video which has been sent to me, my lord, it is running through an entire village area, my lord. The villagers, the residential areas are there. The school is there, my lord. I am told the school children will be passing from there, my lord. If anything, from that, my lord.
How can
it's
poultry the entire village will be overshadowed by electricity line? This is unimaginable at this point of time. Make submissions which can.
Well, at least give the opportunity to the villagers, my lord, who are affected, my lord,
but
before
the
they clear.
villagers will have to say what is the kind of affectation that they are having. What is the effect of the electricity line that is going to pass? It is going to pass through their field, over their houses. What is the
over the houses, my lord? I have stated in my
Show me what is your statement?
But before my learned pen
page.
On a page 12, my lord, paragraph 5. May I read? Third line, my lord. Respondent number 8, by suppressing material facts, the most determining and material facts so suppressed, being that the electricity connection overhead line supplied for and sought to be installed was not an ordinary low tension domestic commercial service connection, but a high tension line of the order of 11,000 volt, proposed to be carried on overhead poles through and over a thickly inhabited residential locality, including the dwelling house of the petitioner.
Yes, Mr. Naik, if you are
carrying on this issue, my lord, I have taken instruction also, though it is served yesterday, even then I have taken. My lord, my clear instruction is this, my lord, from the PWD road, we are, my lord, drawing this high tension line for around 400 meter, where, my lord,
400 meters is a large area.
On the 4 meter, and by the along the side of the, my lord, road, concrete road, not over anybody's property.
But it says it is passing over thickly inhabited residential locality, including dwelling house of the petitioner.
My instruction, what I have collected, to put this question, whether it is covering anybody's house, they have said along the side of the road, inside road, 8 feet road. That is the, my lord.
No. Whether it is, what is the answer to this in yes or no? Whether it is going over anybody's house
No,
or not?
My instruction is this.
No.
Not in writing, but overall, my lord, instruction I have received over phone. No, it is not, my lord, going over anybody's house. It is along the side of the road. It's a and my lord, we shall install a transformer, and from that transformer it will be stepping down low tension line, immediately it will be connected. No pillar to be installed. That's my instruction.
I am otherwise instructed. It's a 11,000 high tension line, naked line.
High tension line cannot be supplied to the poultry. It has to be stepped down. It has to be brought down, and then the low tension line will be supplied. High tension line, if you supply to somebody's house or somebody's business house, it will be blown. It can't be high tension. It has to be stepped down. from one portion to the other.
DTR will be installed. After that, DTR will distribution transfer will be installed.
But his specific submission is that it is not passing over anybody's house. It is going across APWD road.
But my lord, that is my instruction, my lord.
But a video has been supplied to me.
Video, I will not.
No,
be
it
able
is
to
my
reply on
categorical instruction, my lord. This is actually passing. through.
Mr. Nag, you file a report in the form of an affidavit. Mr. Naik, in
People
the
also
form of an affidavit. What is the immediate?
But
problem
only
that-
difficulty is this, my lord, pursuant to the order of my lord. And after that, my lord, the DM.
No order of this court to do it immediately.
No.
Only you are
District
sent back to
magistrate.
the- Yes.
District magistrate will pass the order, he would take up the job immediately, and we have taken up the job. The day before yesterday, we wanted to move, and installation were likely to be done. Prior information was
So
given.
you file a report tomorrow then?
No, 1 second, lord. So
No,
tomorrow,
otherwise I will have to say that he will not pass over anybody's line,
Well, tomorrow-
anybody's house.
we are solving. I only.
So I will say that I will
Yes,
pass
yes.
that order that the lines will not be drawn over anybody's house till such time that you file the report. That should save you.
Lordship.
My lord, my lord.
Lordship.
My lord, can you come to the order passed by the DM, my lord, page 54, my lord.
Page
Middle portion,
54.
my lord. The added private respondents also appeared through their learned advocate and filed written declaration.
Who are the added private respondents?
Who has the
What are their names? Because if the petitioner's name is there, then his writ petition will not be entertained.
And kindly comes to my lord, page 52,
Page 52.
all have been
annexure P6. Who are the parties, my lord? From 6 to 10.
6 to 10, all are.
These are the
made
only
party.
parties.
But 6 to 10 are the writ petitioners here?
No, my lord. These are the only added.
Earlier writ petition.
Yes, but the writ petitioner's contention is that the writ petitioners are also local residents. They were supposed to be heard. They have not been heard. Now, can you show that they have been heard?
That I have no report, my lord, at this stage, my lord.
That is what
I
is
have received
required.
Only today, my lord. That
Lord,
report,
on-
my lord.
on
But,
this
my lord,
issue-
there is no objection, my lord.
On this
In
issue,
this
my lord,
matter.
I put this question to our mill officers, whether the person moving the matter today, they were there or not. Then, my lord, against that, my lord, my answer, they have answered, they have said that few persons were there. But those who are now moving, we cannot identify them. But it was made known to everybody that this is happening today before the magistrate. So those who are interested, they might be there. But now they also, my lord, they made a hue and cry there in course of the hearing. We have not been intimated. We have not been intimated. That was a hue and cry raised before the magistrate. My
How
officers.
did the magistrate inform all of them?
District magistrate was directed, my lord, to consider the issue and pass an order.
No, district magistrate informed only those persons who were made parties to the earlier.
But
writ
at
petition.
least, at least
No one else.
how
But
district
that
will
was
come to
not-
know.
But
that
that
who will
was
be-
not the
Who
order
are
which was.
initially raised objection, my lord, they have been made party, my lord.
That was not the order which was passed by this court. This
My
court said local residents also.
Lordship,
It was not only private respondents.
Lordship.
So the district magistrate ought to have heard everybody then.
And one question may I put to myself, because it is not in a village. Everybody knows what is happening. So those who are interested, why they are sitting tight on the
Such
issue?
time,
My lord, I made, my lord, kindly, my lord,
till
I
such
made a.
time, Mr. Nayak, your line is not passing through his house.
No, that
Over his house. He
fine,
should
sir.
not
Sir,
have
I will
any
bring
problem.
report. I will bring report.
My
my
lord,
lord.
kindly sees my representation at page 40, my
But
lord.
we are
Before
afraid
the DM.
if it is delayed connection is not
Page
given
40,
for
my
that reason. Lordship knows the consequences. What consequences, my lord, may face WBCTC.
My kindly
That's the
sees
only, my lord.
the
cause of
kindly sees, my lord, annexure P3, page 40, my lord. The representation before the DM, my lord. See the petitioners, my lord.
Page.
Told me, 40. I made a specific representation before the DM, my lord.
The order was passed after this.
Yes.
So
So I was not made a party in the proceeding, my lord.
They could have attended, my lord. Nobody, they are resting.
they have made a representation on 7 July. The order was passed on 13 July. Why were they not heard then? The district magistrate ought to have heard them.
To take instruction.
My lord, I will take instruction. my lord.
Why it is not hard? Disposed of. It should have been taken up together also.
Yes, unnecessarily this writ petition would not have been there. You have served the private respondent.
Yes, my lord. Yesterday I have served, my lord.
Where is your affidavit of service?
No affidavit of service, my lord. Yesterday only I moved the matter, my lord. I tried to serve, my lord.
Ready with an affidavit of service. This is not how you move.
Is also required.
No, not that the petition, earlier petition, respondent number 8. She must be, my lord, the organization should be served. 8. They moved the petition. Kulsan Poultry and
Poultry for
Cattle Feed. At their instance, my lord, petitions were moved. At their
Very well,
instance,
since you have submitted that you are not drawing on anybody over anybody's house.
my lord, I will submit my report also in writing because the overall instruction. Right now, I have taken that. I will
Yesterday, saying he's not drawing over anybody's house. So what stay will you get? I will record his submission. matter to call.
So it is appearing on 24th.
24th, Monday.
No, I shall file the
You will
appeal.
continue the work, only don't draw it over anybody's house. Only that is the restraint.
But only that language may kind of, if it is already over, otherwise, my lord.
I've said over.
Very good.
His
Great.
allegation is over.
Great.
His allegation is over.
We are facing less difficulty because my lord is aware of the situation. Otherwise, grateful lordship.
Today, my lord,
Yes, yes.
private respondent is supposed to give an reply. The private respondent is supposed to reply. But the
Where is Mr. Basu?
I don't know, my lord.
Where is bank? But he will just distinguish the judgments.
No,
Cited by
Mr. Basu has
He's
to be
lost.
heard.
yes, definitely.
That is fallen from his lordship. That where is Mr. Basu?
Definitely.
Again, it will be heard a little bit and then again. শুরু করো না।
আরে বাবা জজ সাহেব বলছেন না আপনি বলছেন শুরু করুন না কি জ্বালাতন বলুন তো
দেখি দিন এনাকে স্টার্ট
Should we wait for 5-10 minutes?
No, no. There's no time. Start.
কাল কে বলবে আজকে
বড়
বলো
ব্যাংক নেই স্যার বলছেন ব্যাংক তো শুনবে কি
ও
আদারওয়াইজ হাউ ক্যান ইট বি
তাহলে
পসিবল
কবে করবে
স্যার আপনার ডেট নেক্সট বৃহস্পতিবার
subject to my lord's convenience in any other thing.
Where is Mr. Basu?
Don't
He is
tell
for
me.
the bank.
Yesterday morning he has called me in early in the morning. He was in Jalpaiguri. I don't know. He has come back. Very well. Then he has come.
No, he will come and again start shouting. Kindly, my lord, give us my lord, tomorrow or day after. Subject to court's convenience.
21 তারিখে কিছু আছে
They
দেখে
have given us extreme indulgence, but there is no end to this. But anyway, কতদিন টাইম দেবে
21 তারিখ
এবং এটা পেরামটেড বলে দিতে হবে
সোমবার
সোমবার দিনই
he's there.
এই তো এসে গেছে না, শুরু কর তোমার জন্য মামলা অ্যাডজয়েন্ট হয়ে যাচ্ছে হ্যাঁ তুমি না থাকাতে দর্শক
adjournment by from the court.
It
No,
is
it has to be. One matter was fixed. Justice Kollajyoti Sengupta sat singly for the first time. One matter was fixed. My lord has fixed it. On that date, some matter came. Mr. Vasu, would you mind if I don't take up your matter today? I don't know what I.
এটা রেখে দিন কার
কবে হবে? কি হবে? কি হবে?
Yes, no, you were not to be seen. That is why we were.
No, that cannot be. That cannot be. They have to argue.
Yes, but you have to reply.
Not today. That is the understanding. They will conclude. They are on the following day. I will complete.
আবার ফলোইং ডে কেন আজকেই করে দাও
আমাদের রিপ্রেজেন্ট আর্গু করি না আমরা এখন
কি
আমাদের রিপ্রেজেন্ট এখন আর্গু করি তো আমার টাইম একদিন দরকার
My lord knows that.
You conclude.
তারপর আবার রিপিটিশন আর্গু করবেন?
হ্যাঁ আমার রিপ্রেজেন্ট
That is the understanding. You started.
You will give reply to both. There is no
Yes.
fresh argument on your writ petition now because your writ petition is only for the DM's inaction.
That's only thing.
Yes.
My lord, only things is that, my lord. I understand Mr.
আমাদের কিছু বলার নেই
Siddhartha is leading me, but he is not there. Let me continue. My lord, I am starting that judgment, my lord, cited by learned friend. With the last judgment cited by learned friend about 2018-15 SCC 99 True Post. Copy. Brief day also.
আমাদের আমার প্রেসে ছিলেন।
ঠিক আছে সেটা মামলা করছিস রাস্তা দিয়ে ও চালা তুমি চালাও আমি ঘুরে আসছি হ্যাঁ হ্যাঁ তুমি তোমার
Before starting my argument, my lord, may I hand over a copy of that order of the last order of the DRT, Honorable Deputy. হ্যাঁ বাবা জিনিস পুরো কি ভালো ছেলে কেন
Yes, which judgment will you, were you saying?
My lord, that is the judgment. Glucose, my learned senior friend has cited
1815.
1815. My lord, in that judgment, my learned senior friend has cited and relied paragraph number 43 to 48 and 56. Now, my lord, please come to that paragraph number 9(1). What was the situation of that judgment passing that the physical possession of the property to be handed over to the purchaser immediately? That was the judgment, and my learned senior friend has relied on that. This is not at all the similar case. Now, my lord, please come to the paragraph number 9. May I read, my lord? On 4th September 2013, the creditor published a notice of sale of public auction in the newspaper fixing the date of auction on such and such at a reserve price such and such. In view of this, the debtor sent a letter to the creditor undertaking that it will pay all outstanding installments by 31st December 2013 and that the sale of asset be deferred up to the aforesaid date. The debtor further stated that they shall not proceed in respect of the securitization application before the DRT. In pursuance of it, the creditor deferred the sale by issuing a public notice on such and such and granted the debtor an opportunity to clear the loan. However, the creditor extended repayment of such and such. Now, paragraph number 10. Thereafter, on such and such date, the debtor gave a letter to undertaking accepting the schedule given by the creditor and also acknowledging the right of the creditor to sell the asset case and default in the case. Well, here all of this paragraph 9, 10 and now my lord come to paragraph number 31. But the last two lines of paragraph number 31. Eventually, the debtor even executed a letter of undertaking acknowledging the right of IFA to sell the asset in the case of default. If I am not paying, you sell the property. So admission over there to sell the property if I not pay. Now, my lord, please come to the paragraph of 44. Well, only I am reading one line in paragraph number 44, just started from 4th line.
Yes.
Consequently, therefore, the order of the district magistrate directing delivery of possession is a void order. So there was an order of the district magistrate. Here, case is not at all similar. My learned senior friend has filed a writ petition for passing an order by the district magistrate. So without the order of the district magistrate and without due process of law, with my respectful submission before this honorable court, this honorable court cannot give the direction to hand over the physical possession by that, my lord. May I take leave to? No, please.
জাজমেন্ট গুলো ডিস্টিংগুইশ করতে নোটসে করে দিতে হবে চাইছি আমি ডিস্টিংগুইশ নোটসে করে দিতে আসি তো মানে কাইন্ডলি মিনিট অ্যালাউ মি আ মোমেন্টস টাইম মিনিট জাস্ট মিনিট দা অন না দরকার নেই ওয়েট করে দেবে the only thing Millard which is left Millard according to me according to Mr. Kormokar also is Millard distinguishing the decisions Millard cited by Mr. Basu. Millard, my learned senior friend has suggested he has not yet opened his mouth. He has to place Millard his writ petition. So Millard he may Millard rely on 2 or 3 more decisions. What Millard I suggest Millard without Millard distinguishing the judgments in a truncated manner. Millard I can do it now. But Millard if Millard kindly permits me 10 minutes time,
Once Mr. Basu concludes,
Mr.
only
Basu, if
for
you are relying on any
distinguishing
new
the
judgment,
decisions, nothing else.
if you wish to rely on any new judgment,
Rely on a judgment, which is top-courted judgment, that in 14th stage, you have no right of audience. If you have no right of audience.
you know what he is going to rely
You
on.
have no right of audience with the DA, district magistrate. No right of audience with the High Court also. Because your lordship is not deciding 14. Lordship is only, if satisfied, delegate to the authority, you decide.
Kindly, Millard, take note of the fallacy, Millard, in the argument advanced. Millard, my learned senior friend is suggesting I have no right, Millard, to be heard while section 14 is being taken up. And my learned senior friend in the same breath, Millard, has also made a statement that my lord is not hearing section 14. Millard, I have never come across any judicial decision which says that despite being added, Millard, implicated as a respondent in a writ proceeding, Millard, his mouth can be shut. হ্যাঁ করা আছে আমি নোটসে দিয়ে দিতে চাইছি কোনো দরকার নেই হ্যাঁ so what now Millard, should I Millard start distinguishing the judgments, or I think Millard let Mr. Basu Millard first sir.
Said that he is only.
So that Millard, that I have distinct. My lord is not taking judicious note of the previous decisions then, Millard, which are cited by Mr. Basu.
Of course.
Oh, my lord is fine.
Because he has argued that. I cannot.
Oh, he is adding to it.
Two matters. One is section 14 delegation, another is
Sir, আপনি
the
আগে যেগুলো বলেছেন সেগুলো রিলাই করছেন ব্যাস ওই মামলা
in the matter of Mr. Bhattacharya's writ petition.
আচ্ছা 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 কি কি জাজমেন্ট সত্যাংশতে দেখিয়েছিল বলো মনে হয় না দরকার আছে দাদা অযথা সময় নষ্ট করিও না কাইন্ডলি Millard take Millard the judgment Millard এটা তো সত্যাংশতে সাইট করা তো Millard বাছাজ নাহার 2008 volume 17 সত্যাংশতে যে জাজমেন্টগুলো সাইট করেছিল পরপর বার করে
Yes, Bachaj Nahar.
Yes, Millard, page 491.
Yes.
Millard, this was relied upon, Millard, to impress upon your lordship that Millard, what would be Millard the consequence of Millard not pleading something Millard in a writ petition. Millard, this Bachaj Nahar and all Millard, the paragraphs which were Millard relied upon are paragraphs 18, 23 and 24. Millard, just Millard, have a look at Millard these paragraphs, or kindly take Millard the head note. Millard, this is Millard paraphrase from the paragraphs.
I can remember once I cited one judgment of 1984 for Justice Ajay Rai and said, Mala, kindly see the head note.
Millard, those days.
Told me and said, don't show any head note after
No,
1975.
because Millard, those are editorials. Those are made by editors. Here, Millard, these are paraphrase from the paragraphs. This is not Millard really head note.
Head note.
Really not head note. Millard, after held. Kindly take Millard paragraph 18 Millard. I just wanted Millard to breeze the time. If my learned senior friend is Millard insisting upon this.
They have delayed 10, 11, 12.
Kindly Millard turn to Millard page 10. Paragraph 10 then. The High Court in this case has Millard kindly arrived at paragraph 10.
Yes.
তো বসে পড়ো দাদা আর আমাকে বলতে থাকো It is obvious yield to cut delay and hardship that may ensue by relegating the plaintiffs to one more round of litigation has rendered a judgment which violates fundamental rules of civil procedure. The rules breached are no amount of evidence can be looked into upon a plea which was never put forth in the pleadings. A court cannot make out a case not pleaded. A factual issue cannot be raised or considered for the first time in a second appeal. The object and purpose. The Civil Procedure Code is an elaborate codification of the principles of natural justice. Provisions are so elaborate that many a time fulfillment of procedural requirements of the code may itself contribute to the delay, but any anxiety to cut the delay or further litigation should not be a ground to flout the settled fundamental rules of procedure. Be that as it may, we will briefly set out the reasons for the aforesaid conclusions. The object and purpose of pleadings and issue is to ensure that the litigants come to trial with all issues clearly defined and to prevent cases being expanded or grounds being shifted during trial. Its object is also to ensure that each side is fully alive to the questions that are likely to be raised or considered so that they may have an opportunity of placing the relevant evidence appropriate to the issues before the court. This court has repeatedly held that pleadings are meant to give each side intimation of the case of the other so that it may be met to enable courts to determine what is really at issue between the parties and to prevent any deviation from the course which litigation on particular causes must take. The object of issues is to identify, my lord, may I skip over? Kindly now, my lord, straightway come to paragraph 18. A perusal of the plaint clearly shows that the entire case of the plaintiffs was that they were owners of the suit property and that the first defendant had encroached upon it. The plaintiffs had not pleaded even as an alternative case that they were entitled to an easementary right of passage over the scheduled property. The facts to be pleaded and proof for establishing title are different from facts to be pleaded and proof for making out an easementary right. Then, my lord, what is easement? My lord, paragraph 19. Paragraph 20 says pleadings necessary to establish easement by prescription, etc. Right of easement, difference between title and easement, my lord, is discussed. Then kindly take paragraph 23. My lord, in the light of this discussion, and my lord, the fundamental fallacy in the pleading made in the plaint. The suit was founded on an assertion that we are the owners. In course of trial, my lord, an alternative case was attempted to be made in the judgment, my lord, under report, that even if we are not owners, we have easementary rights. There, my lord, the Honorable Apex Court held that you cannot have a contradictory case. The moment you are asking for an easementary right, you are giving up your ownership. An owner cannot have, my lord, an easementary right over his own property. So this is fundamentally breaching what you have stated on oath. My lord, kindly then take paragraph 23. It is fundamental that in a civil suit, relief to be granted can be only with reference to the prayers. My lord, kindly pause here for a moment. Kindly, my lord, remember those decisions where, my lord, every honorable court has said that in writ proceedings, even reliefs can be molded, which cannot be done in a suit. That apart, in civil suits, grant of release is circumscribed by various factors like fee, limitation, parties, as also grounds barring relief like res judicata, estoppel, etc., etc. Therefore, it would be hazardous to hold that in a civil suit, whatever be the relief that is prayed, the court can, on examination of facts, grant any relief as it thinks fit. That was the touchstone. That was the litmus test applied, in this case. And now, my lord, once, my lord, the judgment, elaborate decision of my lord Justice Dipankar Datta has come, which takes care of everything. My lord, apropos, my lord, a writ proceeding. Possibly, my lord, these judgments are no more applicable to a case. And even if my lord holds that these are applicable, it supports my case because this first does not deal with, my lord, writ petition, which, my lord, is not in the same footing like, my lord, a suit. My lord, what troubled their lordships, my lord, sitting in the Honorable Apex Court was, if today I, my lord, take, my lord, the argument advanced, which is contrary to the pleadings, my lord, I have to grant a relief not claimed in the plaint, which my lord can grant in a writ proceeding. Now, the second decision which, my lord, my learned senior friend has cited is, my lord, Anathula Sudhakar, 2008, volume 4. Supreme Court cases, page 594.
Yes.
Yes. Kindly, my lord, take. Can you bear with me for a moment? My lord, paragraphs 13, 14, 15, 16, and 21. Kindly, my lord, straightway come to paragraph 13. Regarding question number 1, my lord, may skip over 13. We may, however, 14, my lord says, we may, however, clarify that prayer for declaration will be necessary only if denial of title by the defendant or challenge to the plaintiff's title raises a cloud on the title of the plaintiff to the property. A cloud is said to raise over a person's title when some apparent defect in his title to a property or when some prima facie right of a third party over it is made out or shown. An action for declaration is the remedy to remove the cloud on the title to the property. On the other hand, where the plaintiff has clear title supported by documents, if a trespasser without any claim to title or an interloper without any apparent title merely denies the plaintiff's title, it does not amount to raising a cloud over the title of the plaintiff, and it will not be necessary for the plaintiff to sue for declaration, and a suit for injunction may be sufficient. Where the plaintiff, believing that the defendant is only a trespasser, files a mere suit for injunction, and in such a suit the defendant discloses in his defense the details of right or title claimed by him, which raise a serious dispute of cloud over the plaintiff's title, then there is a need for the plaintiff to amend the plaint and convert the suit into one for declaration. Alternatively, he may withdraw the suit with permission to file a comprehensive suit. He may file the suit for declaration and consequential relief. In a suit for perpetual injunction to restrain the defendant from interfering with the plaintiff's position, the plaintiff will have to establish that as on the date of the suit, he was in lawful possession, etc., etc. Then kindly take, my lord. There is a দরকার নেই। My lord, that, my lord, I unnecessarily, my lord, wasting my lord's time. My lord, this judgment was on the proposition that, my lord, since that was not done by the plaintiff, my lord, the suit was not proper. My lord, in that context, my lord, what are the relevance of pleadings were, my lord, looked into? My lord, a suit was instituted saying that I am the sole title holder, he is an interloper. Defendant came, my lord showed some document established to demonstrate his, my lord, purported title to the property. The Honorable Court was of the view, my lord, having confronted with, my lord, these documents, you either amend your plaint or else, my lord, your suit may fail. And, my lord, these are all relatable to suits. My lord, the next one is Ishwar 2005, volume 7.
Which one are you showing now?
2000, my lord, paragraphs 23, 25, 26. My lord, if I am not mistaken, my lord, my learned senior friend, my lord, wanted to argue that, my lord, principle of res judicata. Oh, I'm sorry. My lord, Ishwar 2005, volume 7, Supreme Court cases, page 190.
Yes.
Wait, koro. My lord, kindly take the trouble to have a look at paragraphs, my lord, 23 onwards. My lord, the contention of my learned senior friend was the principles of res judicata apply. My lord, section 11 has, my lord, so many explanations, on of which explanations say, my lord, if I am entitled to take a point, my lord, in a proceeding, and I, my lord, again, my lord, that relates to suit, and I do not take that point,
have taken, but
constructive, res judicata. Kindly, my lord, turn to paragraph 23.
Paragraph?
23.
23.
Yes, my lord. Yet recently in Shami Atmananda, in which one of us was a party, the court observed the object and purport of is to uphold, res judicata is to uphold the rule of conclusiveness as to points decided earlier on fact or law in every subsequent suit between the parties once the matter which was subject matter of least to determine, no party thereafter can be permitted to reopen in a subsequent litigation. Such a rule was brought into statute book with a view to bring any litigation to an end so that the other side may not be put to harassment. Principle of res judicata envisages that a judgment of a court of concurrent jurisdiction directly upon a point would create a bar as regards a plea between the same parties in some other matter in another court, whether the said plea seeks to raise afresh the very point that was determined in the earlier judgment. Then, my lord, Ishwar, the state of MP quoted, yet again in Arnold, it was held issue estoppel, my lord, action estoppel and issue estoppel. Cause of action estoppel arises where the cause of action in the later proceeding is identical to that in the earlier proceeding, the latter having been litigated between the parties, same parties or their previous, and having involved the same subject matter. In such a case, the bar is absolute. The discovery of new factual matter which could not have been found by reasonable diligence does not, according to the law of England, permit the latter to be reopened. Issue estoppel may arise where a particular issue forming a necessary ingredient in a cause of action has been litigated and decided, and in subsequent proceedings. Here also the bar is complete in regulation. I'm just trying to find out how it helps my learned senior friend. Then 25. The Constitution bench held principle of res judicata is also applicable to writ petition. There is no quarrel with that proposition. Tried that the principle of res judicata is also applicable to writ proceedings.
Para 33.
Yes, Milord. I'm so grateful. The High Court, in our opinion, although has a wide power in terms of Section 107 of the Code of Civil Procedure, but it could not have gone outside the pleadings and make out a new case. Very well. Milord, pleadings include the documents. Milord, when we file a 711 application, Milord, if I have correctly learned it from my learned senior friend, Milord, subject to my limitation of understanding, Milord, a 711 application can be filed saying that Milord, a suit is barred by law, relying upon a document which is relied upon in the plaint or annexed to the plaint. So, Milord, pleadings include not only, Milord, what is stated on oath, but also, Milord, the documents annexed. Milord, the submissions that we are advancing are based on the documents which are on record, brought on record by either my learned senior friend or, Milord, by the auction purchaser. So, Milord, nothing has been pleaded or orally argued before your lordship which is imported from outside, Milord, what is on record. So, Milord, I say Section 107, Milord, this bar, Milord, the caution, Milord, uttered by the Honorable Apex Court does not apply here because nobody has gone beyond what is there on record. So, Milord, Section 107 of Milord CPC, Milord, I need not even take Milord resort to that. Milord, I am within the pleadings. I have not gone outside the pleadings to make out a new case. Then, Milord, 2024 volume 20 SCC, page 23, Allahabad University. Paragraphs, Milord, 46 to 52, my learned senior friend has relied upon.
Pinching. Probably he has forgotten he is not appearing for the writ petition.
Milord, still, Milord, I have not forgot my duty, Milord, as an officer of the court to assist here.
He is supporting the writ petitioner here.
No pleading of his.
He is supporting the writ petitioner here.
Understand? There is no pleading of Mr.
Two admissions. One is, Milord, his shoes, Milord, has started pinching him. Milord, kindly take paragraph 51. My learned senior friend has relied upon paragraphs 46 to 52. Kindly take paragraph 51.
Paragraph
51.
51.
Milord, I am just rendering my, Milord, limited assistance to your lordship. The difference in pleading, my lord, is 51.
Yes.
The difference in pleading in respect of civil proceedings and a writ petition was succinctly noticed in Bharat Singh. When a point which is ostensibly a point of law is required to be
cited. You had cited Bharat Singh.
My learned senior friend has cited this decision.
Yes, Bharat Singh you had
Correct.
cited.
Correct.
That is quoted there.
So, Milord, Milord makes a difference. Milord draws a line of distinction, wide line of distinction between, Milord, pleadings in a suit and pleadings in a writ. And my lord, it says when my lord a law point is involved, and my lord, there are evidences before your lordship. My lord is hearing us, my lord, in a summary proceeding on affidavit evidence. So whatever documents, my lord, are annexed to the pleadings are, my lord, evidences adduced before your lordship. So, my lord, it is a far cry to say that my lord cannot look into the evidences. Rather, my lord, I would, my lord, most humbly submit. It's a duty, my lord, of the Honorable Red Court, my lord, to look into the evidences which are adduced, my lord, in the form of annexures to the, my lord, writ petition in a summary proceeding. Now, this is affidavit evidence. Kindly, my lord, just take note of, my lord, what is quoted from Bharat Singh. My lord, that gives the answer and clinches, my lord, the issue.
Yes.
It says, well, just a minute, I cannot resist my temptation, Miller, to just read one line. In a writ petition or in a counter affidavit, not only the facts, but also evidence in proof of such facts have to be pleaded and annexed to it. Based on the aforesaid authorities, we hold that while deciding a writ petition on the basis of affidavits, the writ court's inquiry ought to be restricted to the case pleaded by the parties and the evidence that they have placed on record. So, Milord, this is a conjunctive, Milord, and Milord, these are evidences. Milord, if my lord is satisfied, Milord, looking at the evidence that, Milord, there were illegalities resorted to, Milord, by the bank in putting the property on sale. Some, Milord, mandates of the statute were not followed. Then, Milord, the writ petitioner, Milord, the secured, so-called secured creditor, cannot, Milord, ask for a mandatory indulgence further in the form of, Milord, a writ of mandamus. Then, Milord, 2024, volume 6, Supreme Court cases, page 579, paragraph 30. Paragraph 34.
Paragraph 34 of which one?
Milord, this is PHR Invent Educational Society.
Yes.
Milord, paragraph 34 is the paragraph that, Milord, my learned senior friend has relied upon. In our view, the High Court ought not to have taken into consideration that the confirmed auction sale could have been interfered with only when there was a fraud or collusion. The present case was not a case of fraud or collusion. The effect of the order of High Court would be again reopening the issues which have achieved finality. My lord, here in our case, my lord, looking at the evidence adduced in the form of, my lord, documents annexed to the pleadings, my lord, a fraud on the statute is apparent. And my lord, why I say this? My lord, I have shown, my lord, large number of discrepancies, factual discrepancies between, my lord, the documents and the averments.
No, but that is qua his writ petition before this court, not qua the sale. The fraud that you are arguing is in respect
Before
of
this honorable court,
yes,
on law.
but that would not invalidate the sale. Suppose I accept your case at face value, then this fraud will not vitiate a prior sale.
Today, my lord, nobody is before your lordship to set the sale aside. He is
This is fair.
no. Not on the ground of illegality taken resort to. My lord, he is saying, my lord, I have not got my property, my
Which
money.
is why his submission
Correct.
is that.
But while examining that, if my lord finds that, my lord, there are illegalities, my lord, in the sale notice, my lord, I ask myself, what would be, my lord's duty? When my lord finds that not, my lord, fraud on, my lord, this honorable court or fraud on the section 14 authority, I say, my lord, these are fraud on law, fraud on, my lord, statute, which are, my lord, more fundamental and more, my lord, egregious. That's, my lord, my understanding of, my lord, what the bank has done. And then kindly take, my lord, paragraph 37 of, my lord, the report. It could thus clearly be seen that the court has carved out certain exceptions when a petition
That is
under
on entertainability of writ petition.
Yes.
That's settled. You need not.
It has acted in defiance of fundamental principles of judicial procedure, resorted to invoke provisions which are repealed, has not acted in accordance with the provision of enactment in question. My lord, this is a subject matter of inquiry before your lordship. 37 Roman 1. Whether the statutory authority has not acted in accordance with the provisions of the enactment in question. My lord, that has to be, my lord, in my humble understanding, my lord, a subject matter of inquiry when, my lord, evidence is laid. My lord, the Honorable Court possibly, my lord, could not shut eyes to, my lord, the illegalities which are ex facie apparent. My lord, here, my lord, there is no, my lord, requirement of, my lord, undertaking a roving inquiry whether or not there was an illegality. My lord, it's apparent that, my lord, the encumbrances known to, my lord, the secured creditor were not disclosed. It's, my lord, apparent. Encumbrances in the form of tenancy, encumbrances in the form of alleged unauthorized construction, encumbrances in the form of pendency of litigation, nothing was disclosed in the sale notice.
Yes.
Then, my lord, কত দেখিয়েছেন তো আপনি বাবারে বাবারে। My lord, 2024 volume 2 Supreme Court cases, page 1, my lord's favorite decision, Selid LLP.
Not my favorite. I didn't argue much on this.
No, my lord has, my lord, argued on this.
On this, very little.
My lord, paragraphs 110.1 and 110.3.
One 110.
My lord, Selid LLP, my lord, this Bafna Motors, my lord, we often call it Bafna Motors decision, is, my lord, an authority on the proposition that, my lord, a borrower loses his right to
Publication.
redeem.
On the date of publication.
Then, my lord, why I trouble your lordship on this? My lord, here the prayer is not to set aside sale, my lord, on the grounds available under section 70. Here, my lord, the case is completely different.
The auction purchase is aggrieved by the bank's inaction.
Yes. And then, my lord, AIR 1976 Supreme Court, page 160, paragraph 15. কত দেখিয়েছেন বাপরে বাপ, আর বলছেন আমি শুরুই করিনি মামলা। Miller, this again deals with a suit. Paragraph 15
Fraud
says, Miller,
is to be pleaded or 46 rule 4.
You have not cited. The argument of the bar, that is a fraud. Then I tempted to cite.
Miller,
It is not fraud.
fraud are of, Miller, maybe of different kinds. Fraud on party, fraud on facts, fraud on court, fraud on law. Miller, if this is a fraud on party coupled with fraud on facts, like, Miller, documents, Miller, forged, etc., etc. But, Miller, if a fraud on law is, Miller, apparent from the document, that need not be pleaded. Because, Miller, there cannot be any estoppel against statute. And last one, my learned senior friend cited 2018 volume 15 Supreme Court cases, page 99. This is, Miller, on the proposition whether section 14.
Yes, he started with that.
Next week, any day.
You also wanted it.
If you want to say, let him conclude.
You have to say something.
Then let him conclude.
On that day, once he concludes, you finish. Because I don't think.
What new things come from the bar, I don't.
Mr. Kormakar won't spare me. Miller, he wants me, Miller, to once more remind your lordship of, Miller, the Baliram decision of Justice Dipankar Datta. How to, Miller, read a pleading.
Yes,
Miller,
yes, that is on record. My lord has finished it.
Miller, I was afraid of losing the fee if I do not remind your lordship. So
at
Sorry.
12:30.
Grateful, man.
12:30 is safe zone.
Safe zone. Nowadays, all Jonas. Scenario has changed, not the zone of life. Me, I am no more in the helm of affairs.
No, but still Friday 3:30 is, Friday 3:30 maybe.
Why not? I can say in open court also now 3:30 also, my lord, if court does not rise and court does not, he was compelled not to rise by the advocates. Court was not compelled to rise by the advocates. They appeared. How the court can say no, I will not take up. Scenario has been changed.
Hey, call করে দে।
Hey, কোথায় গেল?
ও কি উঠবে? ও কেন উঠবে?
ডাকবে তো কাউকে। এখানে একটা আবার ইয়ে আছে তো অ্যাপলেট সাইড।
ও হচ্ছে
28th.
my lord.
Yeah. Any time limit being set for the preponement, my lordship? Great. Great. Great.
Question number two, WBSC.
I beg to appear on behalf of the petitioner. So before I start, my lord, I tender my unqualified apology for not appearing on the last occasion. The respondents are supposed to file their affidavits because when this matter was called on first, my lord, the respondents were directed to file their affidavit in opposition matter. Till date, they have not filed any affidavit, my lord.
Well, ready, my lord.
The petitioner.
This entire matter pertains to the fact that whether the submersible pumps are installed at a distance of 200 meters to each other or not. Now, my lord, this what they're annexed in the petition, lordship, is the earlier notification which says that this block, Pandua block, falls under the critical zone. However, subsequently, lordship, I have the instructions with me. It falls under the safe zone. Now, my lord, once it falls under the safe zone, this 200 meter part no longer depends.
So can you come to my prayer? May I read? A read in the nature of mandamus being not issued by directing the respondent authorities to take an initiative and to prevent the private respondents from installing / sinking illegal / unauthorized submersible pump and to run / incinerate the same, and the State Water Resource Investigation and Development Department be directed to conduct necessary physical inquiry in respect of the plot being such and such, lying situate at Moja such and such, within the jurisdiction of such and such. In terms of the petitioner's representation being annexed P2. Now let's kindly come to annexed P2 once. It starts from
Page 19.
Page 19, madam.
19.
19. This was addressed to the Assistant Engineer, Hubli, West Bengal. And the subject, বিষয় বেআইনিভাবে মিনি টিউবওয়েল বসানোর বিরুদ্ধে আপত্তি. And my lord, thereafter the second, my lord, the next page is addressed to the Executive Engineer.
Yes, but what is the illegality?
Yes, my lord. Because this private respondent has violated the provisions contained in Section 7 of the Act of 2005, my lord. May I place before your lordship the relevant provision, my lord? Lordship, I do not have the book, but I. Section 7, subsection 1. On and from the date of coming into force of the Act, but I'm reading out the provisions contained in the West Bengal Groundwater Resource Management Control and Regulation Act 2005. Section 7, subsection 1.
on and from the date of coming into force of the act, no user shall sink any well for extracting or using groundwater without obtaining a permit issued by the state level authority or the district level authority or the corporation level authority as the case may be, as stated in subsection 3, subsection 4 or subsection 5, in such form as may be prescribed, provided that where any user extracting or using groundwater for irrigation or domestic purpose sinks any tube well or hand pump, or B, any well for which such extraction or use is made without the help of any mechanical or electrical device, such user may sink tube well or hand pump or well as the case may be without obtaining a permit from the concerned authority as provided in this section. Therefore, my lord, this section makes it mandatory for any individual who desires to, my lord, sink a tube well and who want to extract ground level water with the mechanical or with the help of electricity. So this is a mandatory provision, my lord. Therefore, this private respondent who, my lord, I have made allegation against them that they are trying to extract ground level water by installing a submersible pump with energization without having any permit from the concerned authority in terms of section 7 of this, my lord, act. If the private respondents can show that yes, they have obtained a valid permit as required under the section 7, my lord, my case goes, my lord.
You see the first proviso.
Yes, my lord. Provided that where any user extracting or using groundwater for irrigation or domestic purpose sinks any tube well or hand pump or any well for which such extraction or use is made without the help of any mechanical or electrical device, without the help of any mechanical or electric device. In such case, my lord, they do not require any permission from the authority, my lord. Otherwise, in case of
this B will go only with B. The
Yes.
B will not go with A. So any tube well or hand pump or such and such without the help of any mechanical device. So tube well cannot be without electricity. Tube well cannot be without mechanical device. Therefore, tube well or hand pump, such user may sink such tube well or hand pump or well as the case may be without obtaining any permit. So for the purpose of this, it can be without permit. That is prima facie reading of the proviso.
And when the submersible pump is installed and the water is extracted without the help of electricity, in such case, my lord,
in all cases, it will be only in case of the well from which extraction or use is made without the help any well. If it is any tube well or hand pump, it can be with electricity if it is for irrigation purposes.
But my lord, here in this instant matter, my lord, the private respondent has already applied for electric connection, my lord. The electricity office has already paid visit for my lord extending the electric connection, my lord. So this cannot be that this pump is.
How do you say that this section 7 is not applicable to you?
Regarding this section 7 instructions that I submit in Honorable Lordship, but as per my instruction goes, since as per their own submission, in paragraph number 12.
No, what is there to show? What is there to show that this act will only apply in cases of green zones? Semi-critical and critical zones, and not green zones.
Lordship, that part I'm taking, sir. My lord, fixes up a date, Lordship, I will come back.
When you tell me,
Anything I have the convenience.
you have to take. Learned advocate appearing go through your house, no matter how rampant it is.
Cutting of trees. One small boy tried to videograph the situation, my lord. He was taken by the IC before the and arrested.
Cutting of trees is not a part of your writ petition. You don't make these prayers in the writ petition orally, you submit. How will I take?
Property has been
You have not made this prayer in the writ petition that trees are being cut. You are now saying that. How will I take cognizance of that? You make out new cases first. Try to lay down all your cases, all your points in the writ petition, then argue.
Petitioner's property is being
Forgotten will not do. How will I insert it?
Petitioner's property, what my lord has protected.
Property, I have said that it will not go before your, it will not go over your house. That was your prayer that I have said it will not be done. No, you are told many things. How can it be done? Don't take the court for granted. Then you should have made this prayer at the time when the matter was taken up, that trees are being cut or trees will be cut. There is no pleading also to that effect. Chalo. Yes.
নাইনটিন হ্যাঁ তাহলে কি হলো?
I'm for the petitioner. On last occasion, you have
Yes, it was on you also, not only him. It was your matter which was supposed to suffer the brunt of dismissal. So don't point out at him. You tell me what you have to submit.
my submission. That will be, yes, sir.
You have got that? Peerless. You could not find it.
তুই পেয়েছো নাকি? একটু দেবে আমাকে? একটা কেউ নিয়ে আসে?
Soft copy. Soft copy.
You've seen it? Yes.
You were there, Lord.
This was the point taken.
Your Lordship, they have lost my deed and didn't even bother to inform me for 1 year, Lordship.
Your client is aware.
The pleading is there. He was aware since May 2025. Pleading is to that effect. Para 8. Page 5. The bank has informed you it is not traceable. It is your pleading.
No. If the sale, you are aware of the sale, you have sold your own property. Then
in the month of March 2025. And the writ petition filed in the year 2026.
This was on the last day of before the summer vacation. Yes.
Yeah.
The petitioner alleges arbitrariness on the part of the respondent bank.
Lordship, I am appearing for the respondent bank, Lordship.
I am for the petitioner.
Even Lordship, our bank was informed that a new advocate has been engaged in this matter, namely her.
It is appearing for dismissal.
No, Lordship,
My lord, I am
talk of
praying-
settlement is going on between the bank and the petitioner, Lordship.
I am praying for not this week.
No, Lordship, there is a specific
Okay.
instruction, Lordship. He is not appearing for petitioner.
Who is appearing for the petitioner? You or him? I am.
No,
You are appearing. I am.
no, Lordship, actually,
I am making it not this week. Sort out and tell me
Lordship,
next week.
kindly
For not this matter. Not this week. Not this week. Not this. Not this
Lordship,
week.
may I submit one thing? A
The
talk of
summary
settlement has
Wait.
already going on by and between the parties. Petitioner has already submitted a bank demand draft before the bank, and they informed us that a new advocate has been engaged, namely Devlina Das, which is she, and therefore we
You
just
are not there.
yes, Lordship, and therefore we are praying to post this matter in the monthly list of November. During this time, the matter will be settled between the parties, Lordship.
You have taken a change from him. Who is the advocate on record? You are Mr. Patro. Yes, Mr. Patro. So he is the advocate on record. You don't have power now. You have to take no objection from him, madam. Without no objection, you can't appear. You have to take no objection from him. What is it?
Lordship, after
দিদি গরম লাগছে কেন? Yes.
Lordship, on the last occasion, the CSC authorities filed their report. Lordship, kindly sees their report. And I am with the exception to the report.
That filed a report.
Yes.
What was the report?
Their report stated that there is no position in the meter room. That is why they could not effect the electricity connection in the name of the petitioner. Now, Lordship, kindly sees my exception, Lordship, 2 points, Lordship.
দিদি এটা কি দিয়েছেন? এটা WBSCTCL দিয়েছেন, উনি CSC রিপোর্ট দেখাচ্ছেন, কি মামলা দিলেন?
Hanika Begum petitioner.
ফাইল কেন খুঁজে পাওয়া যায় না কেন ঠিক সময়? এটা দিয়ে দিন তো ওনাকে, ফেরত দিন। এটা দিয়ে দিন ওনাকে। ফাইলগুলো আগে সর্ট আউট করে রাখবেন দিদি, খুব অসুবিধা হয় এইভাবে। পাসিং ইট ওভার ফর আ মোমেন্ট। কি কল করলেন? কত নম্বর বলুন, আমি কিছু শুনতে পারিনি।
22, my lord, I beg to appear on behalf of the CS.
Last occasion, Lordship, there was a direction to the file, the opposition, and they replied to that. I'm
May I
filing
hand
the
over a
reply.
copy of the opposition? I have served, no, they have served the reply.
What is the matter?
Lordship,
No,
the
this-
matter is that I am the property holder. I am the owner of the property named 51 2 Chota, 2 Kata, 14 Cheta. And the adjacent plot is 62/1. And there is a common place. That common way extended portion is 62/1. That pathway has been blocked or obstructed by the installing of the meter room by the CSC. And the egress and ingress to that pathway has been just obstructed by that installation of that meter box. That is the main issue of this case, madam. I have the registered deed, and that has been mutated in my name also. I have all the valid documents to that effect. And on earlier occasion, I have the only I have to enter into through a common one, and that is in the path through the flat, and that has been locked. So the pathway has totally obstructed. So the only the way to enter into my plot has been obstructed by the CS. That is my.
We have given a photograph in the affidavit in opposition.
Here, my lord.
Kindly. We have given a photograph in the affidavit in opposition, my lord. My lord, it will show that this is the meter board is inbuilt through the wall, which is the boundary wall. My lord, this has been done in the year 2004. Regarding the common passage, my lord, we don't have any authority or any jurisdiction to comment. My lord, they are wanting shifting of the meter of some persons, my lord, and we, my lord,
Who are the persons? They are
the
parties.
private respondents.
They are where are they?
My lord, I don't know, my lord. And more importantly, my lord, kindly, more importantly, my lord, in the affidavit in opposition, my lord, we have dealt with all the facts, my lord, at paragraph 4 and the sub paragraphs in the opposition, my opposition. In the reply, my lord, if my lord may kindly come, my lord, there is just a mere denial in respect of the paragraph 4 and its sub paragraph. The sub paragraphs even is not mentioned in affidavit in reply. Kindly come, my lord. To their kindly see at page 6, paragraph 17 of their reply. And at parallel to that, my lord, if my lord may kindly see my affidavit in opposition, my lord, paragraph 3, my lord, it starts, my lord. Paragraph 3 is not dealt with, my lord. Even paragraph 4 is not dealt with. My lord, regarding the common passage, my lord, we cannot do, and she is not the consumer. She cannot ask, my lord, for shifting, my lord, whether the consumer has to come. And this is a private dispute, my lord. Let the whether it is a common passage or it has been owned by somebody, let the district magistrate decide.
I have not come before your lordship for adjudication of my ownership, lordship. My only the pathway is obstructed by the CS.
Well, how can it obstruct, my lord? Kindly see the photograph.
The meter room has been installed in the name of that private respondents also. That has been installed. That is admitted in opposition.
Yes, that is there since 2004. And suddenly now he has
everything into the affidavit in reply by para is denial, lordship.
Show me your prayer in the
17 of the
Madam, show me your prayer in the writ petition. You want shifting of electricity supply from common passage? Where? You want shifting from this place to where?
Lordship, that has not been made by the inspection. Only a hazy photograph has been
But you will also have to say where. Shifting from that place to where?
It's convenient to the consumers and the both parties, because that matter has been sent to the amicable settlement for many times. That has been failed, and I have sent the representation, thorough representation.
According to you, there is no other space.
Now, there are 2, 3 things, my lord. Firstly, my lord, this installment has been done in 2004. Secondly, my lord, we are unaware whether that is a common passage or not. Thirdly, my lord,
where it has been installed now, or where
it is from 2004. It is there. I have stated.
Common passage as regards which, the present place of installation or the place of proposed place of installation.
Well, the proposed place, there is no
Nothing has
proposed
been
place. No, there is no proposed place. Kindly, I mean, to bole. the, the present place which was there till 2000 from 2004 it is there. If there is a dispute in respect of common passage, my lord knows it should be determined by this competent civil court. This is one. Secondly, my lord, the writ petitioner is not the consumer of CSC. She cannot ask now, my lord, so without any application, my lord, we cannot shift, my lord. Let first decide.
There is not consumer of CSC.
No. They are asking the shifting of the meter of somebody else. They have not asked for shifting. The private respondent has not asked.
Then I am referring this matter to the district
My lord.
magistrate. Let the district magistrate
My
decide.
lord.
Writ court cannot decide all this.
Lordship, kindly appreciate one thing, that common
Madam,
passage,
district magistrate is the authority who can take decision appropriately.
that has been, representation has been sent to the district magistrate.
And he has not decided. Now I'll ask him to decide. I will ask him to decide.
Consider the representation to that.
Yes.
কোথায় representation?
Legal.
কোথায় representation? District
Anything
magistrate.
after
আমি তো খুঁজে
Where is
পেলাম।
that?
to the district engineer and
Not the district
district
engineer.
engineer.
Magistrate.
68.
Yes, district engineer
District
is.
magistrate.
This is district engineer.
You make a fresh representation before the district magistrate. He will consider. I'll pass appropriate orders. This writ petition.
21.
21 তো হলো নাকি? হলো না? পেয়েছেন?
21. 21, Lordship, I am for the petition. This is the exception to the
Well, today only we received the exception, my lord.
Lordship, may I submit, Lordship? Lordship, by their report, they have stated that the meter room for which we have applied for the electric connection has no space. This is their only allegation. Now, Lordship, kindly sees the photographs.
Moving forward.
I annexed with the exception to the report, Lordship. The entire meter room has enough space to install one and another submission, Lordship.
My lord,
Lordship, may I explain, Lordship, during pendency of this writ petition, Lordship, on 16th of June 2026, Lordship kindly comes to annexure A of the exception. This is page 4.
Page 4. Yes.
After the photographs, the security deposit in the name of Mr. Aryan Pramanik. Lordship, they have installed one electricity meter in the same meter room during which our writ petition was pending. Lordship, kindly sees my case status. The writ petition was filed in the month of May 2026. First order was passed in 15th of June 2026.
My lord, I have to come back with instruction. We have got the particulars today.
He has shown the case status
Yes,
during
my lord.
pendency
Give
of
me
the
2 days
petition.
time, my lord. I'll come back on
Gave
Monday.
to someone else. You are saying that he does not have, for him you don't have space.
Also, the meter room has
Stated
space.
that he should provide us with a suitable space where we can arrange it.
There was
But
space.
I have to
There
seek
was
instruction.
space.
I have to seek instruction, my lord. Keep
How
it
long
on
will it
Monday.
take?
For 5 days, my lord.
5 days.
Or keep it on Monday as per your lordship's convenience.
Monday.
Exception to the report filed on behalf of the
I am for the petitioner, my lord. On the last day, my lord, my learned friend had filed a report on the basis of the writ petition order and granted me liberty to file exception. I seek 1 week of extension of time, my lord, for filing date.
learned advocate.
Last occasion, as per your lordship direction, my lord, they have complied, my lord. Minutes of meeting has been prepared, my lord. So, my lord, kindly time frame is given, my lord, and by giving notice to the petitioner, shifting work should be done.
But may I be, my lord, permitted to just, my lord, submit a lordship small minutes? What happened exactly? My lord's desire was, my lord, the meeting date, venue, everything to be intimated earlier. That was done. They were present. And, my lord, petitioner should be explained what is the utility of this, technical feasibility and all this, the line. So that has been done, admitted by the petitioner. And the comments, my lord, the second page, the petitioner's acknowledgement and remark, pursuant my lord's order.
Madam.
নকশা অনুযায়ী কাজে আমার কোনো আপত্তি নেই নকশাটি বুঝে নিয়েছি
So they will proceed
Time
according
time
to
may be framed, my lord, by giving notice to the petitioner, shifting work will be done. That's my
আমার কাছে
plan.
কপি আছে তো ওটা
এটা জেরক্স দিয়েছি, আমাকে দিন একটা ভালো হয়।
আই এম হ্যান্ডিং ওভার কপি অলসো তো ম্যাডাম।
Get. আমাকে
লিখে
ফোনে
নিন,
পাঠিয়েছে,
দাদা।
প্রিন্ট করেছি।
Number 25, Lordship, I am for the petitioner, Lordship. On the last occasion, Lordship directed the CSA authorities to file a fresh report stating the amount of the outstanding dues.
My lord, it's 6,696.
Lordship, we have no objection, but the only thing new meter we installed, Lordship. Because they have again stated that reconnection in the report.
No, reconnection means it will be in your name. How will you be meter is their property?
Lordship.
Whatever. It will not be that someone will come and claim on the meter. It will be their property. It will be in your name.
Lordship, for reconnection, they will again demand another other documents, Lordship.
No, they have said they will ask you to pay only 6,696 apart from.
Lordship, kindly space.
Apart from the regular
security
deposit
deposit.
and
Lordship.
whatever.
Compliances, whatever is.
No other outstanding. They have given. That is why this report. Payment of outstanding dues is 669682. That is,
We will pay, Lordship.
Grateful, Your Lordship.
a report filed on behalf of the respondent CSC authority.
Exactly. 26. What is
Lordship, this matter has
Yes, yes, there is a mistake in the order. If you see the order, second page,
Lordship, I don't have the order with me now. I don't have the order with me now.
it was said in pleaded as a party to the present application. The main application was 68.
Right.
Present application was this one. So the prayer was for impleadment there.
So this application will be the number.
The other application as well as this application, because this is also I have kept this pending. So I will correct it to that effect. This application has been listed under the heading.
My application. So the issue is actually very short. It's for implementation of an order that was passed by your lordship in an application that was filed by the company. Company is into voluntary liquidation. The liquidators before your lordship, through its constituted attorney, there was an order that was passed, and I'll show that. Well, the dispute relates to certain plots of land where the company that's gone into voluntary liquidation, the liquidator comes to court and says, allow me to sell it. When we are taking steps for selling that property, the liquidator, the state of Bihar comes to court and says, this land is my land. I have a preemptive right over the property. Therefore, allow me to exercise my right of preemption. That right is recognized. But what is the amount that they'll pay is the issue. So the state of Bihar says it's my land. So I have a preemptive right before the company sells it. So now they come to this court and that right of preemption of state of Bihar is acknowledged. But the property was being sold upon valuation at 10 rupees. They say that I have done a market value of this and I have now assessed it at 8 rupees. So I'm exercising my right of preemption. I'm going to pay you 8 rupees and give me the property. This court
all of a sudden, this matter has come up. I'm for the state of Bihar. Your Lordship, no notice, nothing has been served upon us. We filed our oppositions. It may be fixed any time. The learned counsel, Mr. Umesh Kumar Prasad Singh from Bihar is appearing in Singh is appearing from the state of Bihar. So, Your Lordship, he would like to address. Second week of September, anytime, Your Lordship.
আমাদের কিছু ফাইল করা আছে রিপ্লাই টিপ্লাই কিছু
If you want to bring this on record, sir.
আবার হয়ে যাবে ইটস আ অর্ডার অফ কোর্ট উইল জাস্ট রিলাই অন Wait, please, my lord, I prefer. Your lordship will recall, my lord, this is our application for dissolution in the series of, my lord, applications. What was bothering your lordship was, yes, my lord, yes, my lord. The fund position was, my lord, 1,46,478, and your lordship, my lord, had made a query whether, my lord, the books of accounts, my lord, has really been, my lord, audited. Now, my lord, what my lord was submitted before your lordship on the last occasion was, my lord, if the audits are made, then, my lord, perhaps the value, the cost for that would, my lord, supersede, my lord, what is there with the company's accountant. Now, your lordship, my lord, had, my lord, asked whether I had sought for dispensation. My lord, wherever, my lord, the prayer for dispensation was there, the reason as to why the dispensation had been sought for was, my lord, lacking. Your lordship had, my lord, indicated that your lordship would, my lord, take a call on it and decide whether your lordship would, my lord, allow the application or, my lord, pass, my lord. No, my lord. My lord, 1,46,478. The company went into liquidation, my lord, sometime on February 28, 1986. I understand, my lord. We can appoint, my lord. There is no difficulty there, my lord. I am also not standing in the way of that. But then the difficulty is, my lord, it will definitely come. Yes. From a rough estimate, my lord, as I am instructed, my lord, it will surpass this. My lord, I haven't since, my lord, your lordship, my lord, indicated your lordship will take a call, my lord. I'll be very candid with your lordship. I have it. Very well, my lord. I will then in that case, my lord, your lordship, my lord passes this over for a week. I'll, my lord, come back with whatever I can, my lord, even if it's the, my lord, or would your lordship, my lord, I understand it's not my place to, but would your lordship, my lord, then prefer, my lord, a composite application, which is there already in front of your lordship. My lord, what I would then, my lord, suggest that I withdraw this and I make a composite application, my lord, based on everything that I find, put it in, and your lordship decides upon whatever is there. My lord, lock, stock, and barrel. Very well. I shall come. I shall come. Very well.
Lord, I appear for one of the contributories, my lord. On the last occasion, my lord, we had indicated, my lord, pursuant to the scheme of revival being allowed, my lord, there was a permanent stay on the winding of proceedings, my lord.
Please to direct to take out on their part to take out an application.
My lord, yes, my lord, your lordship, I directed the application be taken out for affecting the, my lord, the consequential orders. Now we've taken that application on, my lord. I believe Mr. Ghosh has sought for your lordship's leave to file the application with the short course title.
Yes, in connection with that matter.
Lord also had directed on the last day, my lord, to inquire what is CA1. CA1 is also appearing in your lordship's list, my lord. Your lordship may take it up on the next day with the application itself. Yes, my lord, kindly do. my lord, we have been able to, my lord, trace out a copy of CA1. My lord, CA1 was an application, my lord, for production of the books of records of the erstwhile directors to give effect to the liquidation proceeding. Now, my lord, the fact that the company itself, my lord, the liquidation proceedings have been stated, my lord, CA1 has become infructuous. My lord, we've annexed that in our application, which will come up before your lordship on the next day. I'm grateful.
Wait, please, my lord. Similar, my lord, to item number 3, my lord, 1 week. 1 week.
My lord, this is my application. I have already served the official liquidator. The conspectus of this application, my lord, which is appearing before your lordship today is very small, my lord. So I'll give a 2-minute background, my lord. Essentially, what happened is this company was admitted into BIFR and thereafter admitted into winding up, my lord, in 1997. This ISCO Ujjain Pipe Foundry Limited. Now, thereafter, my lord, the liquidation has been continuing and a lot of orders have been passed, which is not relevant at this moment, my lord. This company, my lord, is or was a wholly owned subsidiary of a company called ISCO Limited. I am today Steel Authority of India Limited. ISCO Limited merged into me, my lord, by an order of this honorable court, my lord, in 2005, with effect from 2005. I'll place that order if required, my lord. So, my lord, what I am on today really is that in the course of this winding up proceedings, my lord, the official liquidator, my lord, had filed a supplementary affidavit sometime in 2024, whereby they had indicated, my lord, the fund position of the liquidation of the company in liquidation, my lord. My lord may straight away come to the order at page 161, my lord, of the affidavit in support of judge's summons. That is in volume 2, my lord. Yes. Where this supplementary 161, my lord, yes. So, my lord, after this court had called upon the official liquidator to file the statement of accounts, the official liquidator had filed that supplementary affidavit, which also I have appended to my application, my lord. Now, at page 161, my lord will kindly see 19th March 2025. This order was passed by the court. I kindly allow me to place that order, my lord. CS such and such is filed by the official liquidator praying for payment of liabilities to various creditors and claimants. Admitted claims and the remaining amount to be paid to different creditors are given in details in the application. Such and such, my lord may come to the third paragraph. The supplementary report is filed today containing a signed statement of accounts of the official liquidator, wherefrom it appears that as on 30th November 2024, the quantum of fund available is 14 crore 12 lakhs and then some figures after that. Total amount to be paid according to the application, as per the official liquidator's own application, the total sum to be disbursed to creditors is 9 crore 85, which means, my lord, that a surplus fund, according to the official liquidator's own admission, of around 4.26 crores is left in the accounts of the company or should be left in the accounts of the company. Now, my lord, I have a Supreme Court judgment where the Supreme Court is saying post liquidation and distribution of the liquidation proceeds among the various creditors, whatever surplus fund is left should go back to the shareholders of the company. Now, my lord, as I have placed today, Steel Authority of India, by virtue of taking over ISCO Limited, has become the sole shareholder of this company in liquidation, which is ISCO Ujjain. So, my lord, my prayer in this application is that surplus fund 4 crores, whatever, as per the liquidator's own accounts, should come back to me, my lord. That is my prayer.
Lordship, I am praying for 2 weeks' time to file an opposition. Because, your lordship, for the disbursement of the funds, your lordship, there are priority basis on the pari passu basis, your lordship, some interest is to be given to the other creditors because they happen to be the contributories. So, my lord, I am just seeking for at least 3 weeks' time to file my opposition.
That is, I am not opposing.
My lord, this is the official liquidator. Your lordship, my lord, had sought for, my lord, a supplementary affidavit, my lord, which sets straight, my lord, all the facts. My lord, may I be allowed to file my competency also? My lord, this is in regard to, my lord, CA 53 before your lordship, which was preferred by the official liquidator. My lord, so far as CA 53 is concerned, if your lordship takes up the judge's summons, my lord, there are certain leaves which were sought for. Now, my lord, on the now, my lord, for CA 53, my lord, there were certain leaves which were sought for. If your lordship takes the summons for direction, my lord, leave be granted to the official liquidator to serve a copy of this application concealed. My lord, this was done, granted and done. My lord, B's leave may be granted to the official liquidator. This was granted by way of order dated June 11th. My lord, similar for C, D, and E. Now, my lord, the difficulty is, so far as prayer D is concerned, my lord, direction which was, my lord, made upon the Tehsildar, my lord, initially when the direction was made, he did not comply. Now, my lord, in 2023, when the matter was, my lord, came up, and my lord, the proceedings before the revenue board happened, and my lord, an order was given, my lord, closing all the chapters, everything was put to rest, saying that all these transfers are fraudulent, and none of this stay, the sales were all set aside. After that, my lord, when we communicated the order to the Tehsildar, my lord, sends us a copy of the, my lord, Jama Bandi is what they call it there. Yes. Now, my lord, it's my lord, called a DLC. Now, my lord, the Jama Bandi recorded, my lord, the name of, my lord, the same person, the mistake of which was corrected by, my lord, the Board of Revenue's order. Now, my lord, this person was, my lord, supposed to come here and, my lord, put in a report. My lord, he did not do so. Now, my lord, the compliance of this, so far as the Tehsildar is concerned, my lord, in respect of, my lord, changing the names and, my lord, putting right, my lord, the Jama Bandi, my lord, that remains today. That is one. I'll tell you, lordship, my lord, that order is, my lord, June 11, 2025. June 11th, my lord, 2025. Now, my lord, there has been an omission, my lord, bona fide, though, my lord, the orders are not annexed. My lord, it's there from records. Now, my lord, June 11, my lord, this was granted. Yes, my lord. Now, there's another thing, my lord, which needs, my lord, to be brought to your lordship's notice. My lord, once, my lord, this person, my lord, did not come for complying, my lord, with the order of the court, my lord, that is the day, that is, my lord, a report was filed to that extent, my lord, indicating that this person was supposed to come. We had gone for inspection. Inspection was not allowed. Demarcation was not allowed. So far as record correction was concerned, that was also not allowed. Now, my lord, there was certain prayers, my lord, which was made, my lord, as part of that report. Now, my lord, what has happened, my lord? I have got a copy of that report, my lord, before your lordship, lord. That also, my lord, had certain, my lord, prayers. If your lordship kindly considers these prayers. This was report which was filed by the official liquidator. Now, my lord, these prayers have also been granted. My lord, this was filed on the 11th of August, 2025. My lord, the prayers have also been granted. My lord, I am just bringing it to your knowledge. Why? Because, my lord, by these, my lord, prayers which were granted, my lord, sale auction that has happened recently, my lord, that auction was also conducted. Now, my lord, this auction was conducted by Railtel. Now, my lord, there are two bidders here, my lord, the highest bidder and, my lord, the second highest. Now, so far as the highest bidder is concerned, the highest bidder has put in, my lord, a sum of 2 crores, 5 lakhs 26,000, and, my lord, the second highest bidder, my lord, has put in 2 crores 26 lakhs. Now, my lord, 26,000. Now, my lord, the EMDs has been retained. The difficulty is, my lord, owing to the corrections which are wanting in the records of, my lord, the Ajmer, my lord, board of the Tehsildars, My lord, the confirmation which, my lord, the official liquidator would otherwise seek for, my lord, in this kind of a situation, my lord, perhaps becomes, my lord, premature. Now, my lord, that record correction order, my lord, is also required today, which is, my lord, perhaps ministerial, which says that this name, it was done by the board, Board of Revenue. Corrections are required to be cut out. There were earlier orders, so far as this court is concerned, for, my lord, coming and putting in a report, was not complied with. However, order has been placed before us. Yes, my lord, there is an order in terms of prayer D, but my lord, prayer D, my lord, in letter and spirit, my lord, was not complied with by, my lord, the Tehsildar. See the translation. Now, my lord will take my supplementary here. My lord takes page 30. My lord, this is, my lord, but a translated copy. But if your lordship takes right, my lord, at this corner, my lord, the bottom right corner, page 30. My lord will see, my lord, at this corner it says, name Motilal, son of Ramlal. What is the heading? Cultivators. 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 Now, my lord, this is one of the mischief which was corrected by the earlier order. The Board of Revenue's order, my lord, if your lordship recalls. My lord, the Tehsildar. The concerned Tehsildar, my lord, in Bhilwara. The Revenue Board's order, my lord, is way back in 2023. 2016. 2016. Yes. The 23. 16. 23. My lord will take page 18.
18.
18. 18. Your lordship, my lord, takes, my lord, page 21. Paragraph 8. My lord. And my lord, it actually, my lord, does away with, my lord. This is the translated copy. My lord takes the page over, my lord, at paragraph 9, if I may read it. As a result of the above consideration, this reference submitted by the state government is being admitted. The disputed land is ordered to be registered in the name of the applicant number 2, Memorial Finance and Investment Private Limited, through Managing Director Hiro Kumar, son of HON'BLE Kumar Sarkar. So let this dispute, my lord, then laid to rest. The correction wasn't carried out. The correction has to be made. This Jamamandi, which is my lord, which is put in, the Jamamandi was put in 2023. Now that happened post. Yes, that continues. That is, my lord, a mission. Yes, 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 my lord. So my lord, that correction needs to happen. And my lord, yes, ma'am. Yes, ma'am. That is, my lord, one part. And the other part is, my lord, with regards to the confirmation of the sale which is being conducted by Railtel. My lord, I am also informed that, my lord, since nothing has happened so far as after putting in the EMD, there is no confirmation order, and my lord, no, my lord, modicum as to how the payments with regards to the money, my lord, is going to be put in the consideration. My lord, perhaps, my lord, the second highest bidder, my lord, wants to, my lord, refund. He wants refund of his EMD. My lord, so far as the highest bidder is concerned, my lord, he wants to push through. So, my lord, my lord, subject to correction, my lord, perhaps, my lord, the order of confirmation would either, my lord, go simultaneously with this order of, my lord, correction of records, because, my lord, my lord, but, my lord, my lord makes it a time bound, puts a time, my lord, one, and my lord, then also, my lord, kindly directs me so that I can notify the highest purchaser, so he, my lord, appears next time, so that if, my lord, on compliance of the first part of it, your lordship can, my lord, then put the modus in which he, my lord, makes the claim. So then I will accordingly make notices. EMD for the one.
for company.
The last order,
Yes, my lord, but
the last order referred, my lord, the affidavit in opposition was not available with
the
the.
entire brief has been misplaced. I request my learned friend to have a copy, to hand over a copy of the company petition, affidavit in opposition and reply.
দিয়ে দিচ্ছি
Down.
কি জজ সাহেব এটা দিয়ে দিন এসছে অপারেশন এসছে
নেই ये
This is the service copy on us, so this can be reaffirmed.
yes, मतलब that must
and then got lost.
मतलब entire brief has been
Not interview, not interview. That is a normal. That's normal. You have to give it in court. You have to give it in court and then got. Yes.
entire brief has been misplaced. I don't
It's
have the
safer.
copy with the.
Safer.
I don't have the copy also.
তিনটে দিয়ে দিলাম
No, no.
Please relax. My lord, yes.
No, I have got it. But may it appear in may it appear on 8th September in the event. 8th September. Because from 14th September I will be out of station till the end of September.
8 September. ঠিক আছে
থাক না কি করে
9 depends. Praying for Northeast week, my application there was a
Your Lordship, I'm appearing for.
Two valuers have been appointed by this court. May I file my valuation report?
Lord, I am for the official liquidator. There are two applications pending before your Lordship.
For one of the applicants.
Yes,
Your
Malad,
Lordship, I'm appearing for respondent number 2. I'm
Yes,
praying
Malad,
for a week's accommodation, Your Lordship.
I think,
No.
Malad, I'll tell your Lordship, Malad, where the matter rested. There was an auction sale notice. Malad, my London friend's client was the highest bidder. At that stage, Malad, I came up with an application saying that I was not aware of the auction sale. I'm interested to give a higher offer. So that was my application. So when this application came up, the court passed two orders. One is 24th September 2025, where the court found that there was some anomaly in the valuation. One valuation report is there, another valuation report differs with this valuation report. So, there was a direction that both the valuers should go inspect the property and file a valuation report.
Jointly.
So, that I think has not come as yet. And then thereafter, there was another order by which the official liquidator was directed to file a status report. That I filed 11th of February.
Malad, this is the status report.
Position, 11th of February is the last order.
Malad,
Status report was directed to be filed.
yes, Malad, the two applications. One application, Malad, CA number 14, that is filed by the official liquidator seeking direction for sale of the assets and properties. And Malad, when the sale was about to confirm, I mean to say, Malad, one of the intending offerers made an offer. Subsequent thereto, my learned friend filed an application, CA number 15, by which my learned friend asks that he can submit more better offer.
I had made an offer of 10 crores.
Then, my lord,
the offer was around 8 crores.
That application was heard, and ultimately, my lord, the Honorable Court was pleased to pass an order on 10th September. And 24th also there's order, my lord. If your lordships kindly see in my report also, my lord, I have annexed those orders. My lord, it was a leasehold property, residual period, and my lord, the assets, other plant and machineries was put up for sale. It was in the Nasik, and my lord, the last order, my lord, if your lordships kindly see the order of the Honorable Justice. Requirement of the status report, that is the Honorable Justice Malad Ravi Kishan Kapoor Malad on 11th February 2026, Malad directed, because two applications, so the present status report was asked for, and that is the
Also, Malad, because of the order of September 24,
yes,
valuation exercise was directed. If your lordship says,
Well, fresh valuation, I am appearing for one of the valuers, I am in panel with the High Court. Well, please may I file my report or may I hand it over to the liquidator?
Malad, the difficulty is that is not in compliance with the order. Malad, your lordships kindly see order dated 25th
September.
Yes. 24th September. Malad, page 105 of the report. And Malad, kindly turns to page 106. Paragraph 4. Considering both the reports, this court finds there are much difference between two valuation reports, and as such, this court is of the view that both the valuers shall sit together and to consider their own reports and also to visit the property in question. Yes, joint, not the single report.
Absolutely, my learned friend is absolutely joint report has to be filed. Well, the only thing is sitting with the other valuer is absolutely, my client has to sit with the other valuer. Well, may I file my report for the time being?
What is the point?
Yes, yes. But I am told that another valuer, Mr. Somor Banerjee, he has admitted in the hospital for his eye operation. So that is the reason.
No, my lord, I have not been. Now almost 1 year, 24th of September. And if it is.
Well, let the official liquidator give a notice to both the valuers.
Why? It is order is already clear. Yes.
My lord, there is some difference between both the valuers, my lord.
But I think, my lord,
Correct, absolutely right, my lord. Let the official liquidator give notice to both the valuers, and then both the valuers will do it.
But there is a huge difference. I am told there is a huge difference in between both.
My lord,
Yes. No.
because there was a huge difference, my lord. My clients, I advise my clients to file a fresh report. Now the difference has come down to nearly 2 crores, my lord.
Yes.
No, there has to be a joint report by both the valuers, my lord.
But I can send a, if your lordships kindly pass an order directing both the valuers again to sit together and to make a, I shall communicate the order. Yes, yes. No, that I do not know, but possibly 2 weeks time, definitely. Yes, 2 weeks, at least 2 weeks, my lord. At least 2 weeks time, so that I can, yes,
নাসিক ফাসিক আছে 2 সপ্তাহের ভিতরে কি
ওটার জন্য না, চোখ অপারেশনের জন্য।
Corporation 2 weeks.
সমর ব্যানার্জি।
Somar Banerjee. Well, I am to other valuer, Mr. Somar Banerjee, he has an eye operation which will take 2 to 3 weeks maximum. Well, but
Nobody representing.
I appear for, my lord, may I seek? I appear for Punjab National Bank. I am the secured creditor in the matter, my lord.
Secured creditor is not.
But nobody is representing the Somar Banerjee. Nobody is representing the Somar Banerjee. But when he,
In case your lordship feels
yes,
fresh,
but then
expenses have to be put in by them, because if your lordship feels further valuation exercise is necessary, all costs and
further valuation exercise have already been done.
all
Directed
assets
to
are
be
in
done
Maharashtra,
directly.
madam.
Already directed to be done. I only have to ensure compliance.
Lord, your lordships kindly provide 4 weeks time.
Yes.
4 weeks time to submit the fresh joint valuation report, because otherwise.
Not do well, because I'll tell you, Lordship, why. The place where the land and everything, factory is situated, that is in Maharashtra.
Mr. Dev, that has already been done.
Yes, yes.
You see, paragraph 5.
The order says fresh valuation.
That has been done. They are not ad idem on the report.
Right.
Which is paragraph 5. They have inspected. They have gone, paragraph 5 says what valuers are directed to inspect the premises in representative official as well as secure creditors. Valuers to inform the date of inspection of the property. So all this has been done. They have to now just file the report.
You have conducted a fresh inspection in terms.
My client has conducted. My client has been there and he has filed this report.
May I?
My lord, the difference in between.
No, Mr. Chaudhary, both the valuers have, because you were also definitely present during the inspection.
No, it is a secured creditor who was present at the time of valuation, my lord. My client was there at the time of valuation.
Yes,
so both the valuers
secured
were there.
creditor, my lord, Punjab National Bank.
Mr. Mukherjee, both the valuers have
Yes.
inspection.
Yes.
Both the valuers have done that.
And at my cost only.
Why single?
Only file the joint
Right.
I think it is awaited.
My lord, in the meantime, my lord, I was respectfully praying for one more thing. If your lordship grants me leave to file my wakalatnama.
We file it in the department.
My lord, department is not taking the wakalatnama because as the valuer, I don't have the entire contract. The department is saying, if the court grants you leave, we will take it. My wakalatnama is ready, man.
File with short cost title diye din ki. Short cost title দিয়ে করে দেবে, অসুবিধা কি আছে? But why, Mr. Official Liquidator, why are you not supplying him the full cost title? He will be able to file.
No, the full cost title I have. Well, they are saying in this main matter, the cost title is not there. I don't have the main cost title. Well, your lordship kindly inspect. Actually, they couldn't, Judge Secretary has been that, but well, will kindly see the wakalatnama.
CP চাইছে, cost title, CP cost title. আছে, CP cost title আছে. But we shall provide the company petitions cost title. We shall.
You have not given the cost title of the CA. You have given the cost title of the CP.
Yeah.
But I don't have it.
My lord, CA number 14 is the cost title of CP.
Well, let the official liquidator provide me with the full cost title.
Very well.
लिखें।
Whatever they are filing, let me have a copy of that. Either the OL or the valuer who's
Filing wakalatnama.
No, no, I'm not saying that. The OL has filed certain documents today. Let me have a copy of that at least.
Very well. The OL has filed status report.
Status report as asked
That
for.
copy I must have, my lord. What are they are saying?
Very well. You supply copies.
Yes, yes.
Let the full cost-title be provided to.
दिए दो वो.
Status report filed by the official liquidator in terms of the order dated February 11, 2026 is taken on record. Full stop. Paragraph. Mr. Chaudhary, learned advocate, appearing for the official liquidator, as well as Mr. Mukherjee, learned advocate, appearing for the secured creditor, submits that both the valuers have conducted inspection of the property in terms of the order dated September 24, 2025. Earlier order dated September 24, 2025, passed in this matter. Full stop. However, fresh joint inspection report as directed to be filed by the said order has not yet been filed. Full stop. Paragraph. Learned advocate, while one of the valuers is represented by learned advocate, the other valuer is unrepresented. Full stop. Mr. Chaudhary submits that the other valuer is indisposed. Full stop. In such view of the matter, this court is unable to fix a date for both the valuers to sit together in terms of the order dated September 24, 2025. However, since almost 1 year has passed since the order dated September 24, 2025 being passed, and the joint valuation report is yet to come. Therefore, the valuers shall, and therefore, it is directed that the valuers shall file their joint report in terms of the said order dated September 24, 2025 by the returnable date. Full stop. List this matter 4 weeks hence.
CA 15, which is my application, can be considered after the valuation.
Yes.
That's a CA 15 Act order.
No, that is 11, possibly item number 11.
Item 11 to call kar do. Please prepare the report in the meantime. What was this for, Mr.?
This is my application for leave to deposit my bid, which was higher than the bids received.
Mr. Sen, learned senior advocate, appears for the petitioner in CA 15 of 2025. Full stop. Since the adjudication of CA 15 of 2025 will be dependent on the result of CA 14 of 2025, list this matter 4 weeks hence on the same day when CA 14 of 2024, 25 now, has been directed to be listed.
I'm grateful. Deeply obliged.
এটা কার হয়ে গেছে? তো 8 ঘন্টা আছে।
second round of litigation. I am the owner of a factory premises which is being lying closed since years. The electricity bill itself will show that the factory was closed and was not being used. Well, also one of the persons who happens to be the husband of the councillor, the then councillor, draws electricity from my electricity line and is running an illegal Toto charging station. First round of then the assessment officer comes, visits, and raises a claim against the owner because the electricity line is registered in my name. I came up and challenged that before the writ court, saying that you could not have, without any notice the inspection report or anything, you could not have done so. The matter was remanded back. Now the assessment officer has passed an officer making it joint and several without being able to show any collusion or connivance of the owner with the person who's actually running the illegal Toto charging station. May I draw your lordship's attention to the to the electricity bill first to show that the godown was lying closed. If your lordship kindly takes up page 28 of my application. This is for the year July 2022, page 28. At the top, your lordship will find July 2022 is written. Your lordship will see your 6 in the middle, your 6 months consumption. Page 28.
28.
Yes, your lordship.
Yes.
Your lordship will see in the top, July 2022 is written, bill date 21st of August 2022. Your lordship will see your 6 months consumption. There's a box in the middle which says units consumed 0 or 1. And your lordship will also be, please do not pay this bill because the net amount is just 120. Your lordship, my first date of knowledge of any proceedings being filed against me is at page 52 on 17th of August 2022 when I received page 52. When I receive a notice under section 41A of the CRPC.
Yes.
Here your lordship will file 2 Omnath Sharma, 1 Omnath Sharma, 2 Rakesh Gupta, and 3 owner of Toto charging garage. So this is the first time that I came to know that any proceeding has been filed against me. And your lordship will kindly see correspondingly paragraph 13 of my petition where I say that pursuant to such notice on 17th of August 2022, I had visited the factory premises since it was lying closed. Paragraph 13, I have stated upon making inquiries and personally visiting the premises on 28th of August 2022, the petitioner number 2 discovered that an e-rickshaw charging station has been set up immediately outside the western boundary wall of the premises. Lordship, I have also annexed the photos which your lordship will find at page 53 onwards. How they have caused pilferage.
Page
53. Your lordship will find the photos as to how they have drawn line from my premises by breaking the boundary wall and they are running an illegal Toto charging station. As soon as I get to know this on 28th of August, I file a complaint on 1st of September 2022, which your lordship will find at page 57. I got to know that the person concerned is one Tarak Singh. Page 57, your lordship will find to the officer in charge. Complaint to Tarak Singh. This is my complaint to the police when I get to know. Upon inquiry, your lordship will see I also received a notice for hearing where the assessment order was already passed at page 71. This is on 25th of August. where the provisional order of assessment was already passed. Your Lordship will kindly see page
Yes,
70.
provisional order of assessment is not passed after hearing. This
Yes.
provisional order of assessment is passed prior to hearing. After this, you are required to have a hearing.
Lordship will see that I have received. You are once again advised to file the written objection and appear before me on 2nd of September. Lordship, on final hearing on 2nd of September 2022, I appear and file a written objection. Your Lordship will find my written objection at page 75. If your Lordship may kindly permit.
Milord, foisting me with a liability, Milord, to defray an amount for which I am not entitled. Milord, this, whatever charging unit or whatever, admittedly, is at the instance of the third party. Now, initially, I came to your Lordship's court. Now, please see the initial order made by your Lordship's court in the writ petition.
180.
Page 180.
This is helping you more than the papers.
Yes.
Page?
80.
No, it is in the second volume.
Page
180.
180, yes.
Now, what is the issue? Please come to this order. The grievance of the petition, I am reading from the third paragraph, is directed against the final order of assessment dated 5th September 22. Briefly, the petitioner is a partnership firm and was carrying on business at Hooghly. Subsequently, the partnership firm stood converted to a private limited. It is alleged that the business of the petitioner was for all purposes closed and the factory premises abandoned. On 11th August, a provisional assessment order has been passed alleging theft of electricity and unlawful carrying of total. It is submitted that an influential representative of a political party had been unauthorizedly carrying on such activity from the premises. The petitioner fairly submits that their only fault was they did not surrender the above electricity connection. By final order of assessment dated this, the assessing officer has rejected the contentions of the petitioner and raised a demand of rupees 1392 as payable from the petitioner. I mean, it is 1392 has today been bifurcated. Half liability on me, the half on Tarok. As payable from the petitioner, the petitioner assails the final order on the ground that the same has been passed in violation of natural justice. On behalf of CSC, it is submitted the final order of assessment warrants no interference. There is no violation of natural justice. The petitioner has been given adequate hearing. It is also submitted that all the contentions of the petitioner have been taken into consideration before passing the impugned order. The private respondent and the state are also present. A perusal of the final order of assessment would demonstrate that in passing the same, the assessing officer has held, I have carefully perused the facts and circumstances of the case. I have also carefully considered the verbal submissions made by Habib Hassan and Omnath Sharma, as well as written objection filed by Omnath Sharma. They have admitted unauthorized use of electricity at the premises, and it is also admitted the supplies are still in the name of Shahara Ayurveda. Now, Shahara was my predecessor. I mean, the name has changed. It is now well settled, etc. Administrative decisions are subject to judicial review under Article 226 only on grounds of perversity, patent illegality, irrationality, want of power to take a decision, and procedural irregularity. Except on these grounds, administrative decisions are not interfered. Similarly, in Univac, such and such judicial orders, his lordship relied on various judgments, and ultimately a perusal at page 4 bottom, internal page 4 bottom, 183 bottom. Perusal of the impugned order would show that the petitioner had specifically raised the point of Toto charging station belonging to one Tarok, who had illegally taken possession of the premises and was carrying out some business. Regardless of the merits and demerits, the assessing officer was obliged to consider the same. In the impugned order, there is no element of why or what to stand on. The impugned order has been passed in violation of natural justice. There are no reasons in the impugned order, and the only conclusion is based on the admitted case of unauthorized use of electricity, etc. In such circumstances, purely on the ground of lack of reasons, the impugned order dated 7th is set aside. The matter is remanded to the assessing officer to hear the same afresh within a period of 8 weeks. Now, thereafter, I have been called for a hearing on 17th of March, that is at page 185, where I furnished this written submission, my lord, running into certain pages, my lord. It ends at page 203. And then, my lord, I have appended electricity bills. Finally, the impugned order is at page 21 of the writ petition. Now, please see page 21. My first submission, my lord, is the second paragraph. Upon serving pre-inspection notice in compliance with such and such, an inspection of the service carried on and the metering system carried on to the sub-caption premises was conducted on 11. During the said inspection, when the undersigned as the assessing officer was present, the following was observed. Electricity was being abstracted unauthorizedly by means of such and such. On the basis of the above observations, I came to the conclusion that unauthorized use of electricity had taken place at the above premises. Other relevant information gathered at site during the inspection, nature of electricity, load, period. Then, my lord, page 22. On the basis of the aforesaid information, to the best of my judgment, I passed a final order, provisional order of assessment on this, wherein this amount was assessed as claim towards unauthorized use of electricity and electric duty payable to the government. The said order, along with photographic evidence of the unauthorized use of electricity, the calculation sheet, and my inspection report was duly sent through speed post. Now, my lord, we have adduced evidence in this proceedings that, my lord, this inspection report and the calculation sheet was not served on me. Till date, it has not been served. My lord, then, in the said order, the consumer representative was provided an opportunity of being heard. The consumer chose not to appear before the undersigned on this. However, in the interest of national justice, etc., my lord, he records. Subsequently, Shahara's writ petition is taken on record. Last but one paragraph of internal page 2. My lord, my written objection is taken on record. And, my lord, 24, my lord, Tarok Singh's submission, who is apparently a party, is also taken on record, 24 top. Then, my lord, internal pay, Roman 1, whether unauthorized use of electricity took place, then determination of liability, then statutory responsibility of the registered consumer. Here, my lord, in 1, he says that said findings are supported by inspection records and contemporaneous evidence and have not been effectively rebutted by any cogent material. My lord, my humble submission to your lordship is, this inspection records, if it's a material against me, I'm entitled to a copy thereof. My lord, elementary principle. If I have a material against me, it was the duty of the assessing authority who is passing the final order, dealing with my case, my lord, to give me that this is the material against you. What do you have to say? He did not. Admitted position factually. Then his determination of liability, statutory responsibility, kindly ignores it. Ultimately, my lord, the composite nature of unauthorized use of warranting joint liability. Then he says, I am jointly and severally liable with Tarok and has foisted me with a liability to the tune of 13 lakhs, 92,000 and odd, my lord, at page 26. Now, Mr. Kothari wants me to, my lord, he is correct. My lord, please see page 25 kindly.
Yes.
The inspection findings. Again, top. And submissions on record indicate that unauthorizedly abstracted electricity was being utilized for running the Toto charging unit, etc., allegedly operated by Tarok. Despite denial, no substantive evidence has been adduced by him to displace such findings. A person who is found to be in occupation, control, or benefited by such use of unauthorized electricity falls within the ambit of person indulging in unauthorized use under section 126. Then this not composite nature of unauthorized use of warranting joint liability. The present case reflects a composite situation where unauthorized use has arisen due to the existence of an active consumer connection coupled with actual abstraction and utilization by another person. So his finding is, I am in no way connected. And in fact, my lord, on the date of that inspection, I was not there. I came to know and I visited, my lord, first is this provisional order I collected from the post office. And I have, my lord, appended an envelope which shows the weight of that envelope, suggesting, my lord, that these inspection records and these minutes and etc. were not served on me. What was served only is apparently the provisional order, if at all, at that juncture. The final order has been set aside. The provisional order has not been set aside. The provisional order gave me a hearing once again, apropos, my lord, the Honorable High Court's order. And Honorable High Court's order, my lord, permitted me to give a fresh, my lord, defense, if at all. And thereafter, my lord, this is the order that has been, my lord, passed. Now, my lord, my first submission to your lordship is on the issue of natural justice. My lord, if documents which have been the basis of a finding, if it is not disclosed, then the same, in my respectful submission, constitutes violation. If, assuming, my lord, I have a worst case, even then, if some material is against me, I am entitled to know the material. Because, my lord, your lordship, the final assessing authority is adjudicating the issue. It is not merely, this is the complaint, so you go to jail. It is not so. It is not so easy. My lord, he is a quasi-judicial authority in that capacity. In my humble understanding, my lord, of the position in law, my lord, no man should be condemned unheard. And your lordship sees, where is the consideration, independent consideration to the material suggested by me? I have a defense. My lord, with greatest of respect, my lord, whatever submissions, it might not appeal to your lordship. But, my lord, the law envisages that your lordship would have to, my lord, give some reasons. The authorities here, the administrative authority would have to give some reasons so as to dispel my defense. My lord, what we have learned from our chambers, my lord, the celebrated cases of Vishwanath Mukherjee, my lord, on perversity. 74 CLJ, page 253 at 313. What is perverse? If materials relevant have been placed and have been ignored, or the decision is on the basis of irrelevant materials. Here, the mindset is illegal abstraction was taking place. On their inspection, they have found it. So, first, the person with liability. His crime is he did not surrender the meter. Milord, I was not in occupation of the premises. I have indicated, Milord, in my response.
That is on merits. So far as your ground of natural justice is the only ground on which you can sail through in this writ petition, because there is an appellate remedy. So if you go on merits, you will have to go.
I am more on the essential part is natural justice.
As far as natural justice is concerned,
yes,
you have to satisfy, because the appellate remedy will be effective only if we have an effective hearing in the before the.
Now, Milord, today there are two ways of looking at a problem. My humble understanding is, let us assume a person who is accused of a very bad offense is before your lordship. It does not mean that his rights protected under the constitution evaporates. He has an inviolable right to defend himself effectively and properly. That right flows from the constitution. And if today my defense, whatever I have sought to place as a mark of defense, if it has not been effectively considered in my most humble understanding and submission, that is a violation. Apart from anything else.
Two things, Mr. Bhattacharya. One is that if you have not been provided with the documents which form the basis of the conclusion reached by the assessing officer, then that definitely is in derogation of the principles.
And just one instruction I need. That's it. Please see, just for your lordship's assistance. Their cases, they have served everything on me. Please see page 73. We will not resume tomorrow. Please see page 73. Please see the weight. Kindly see the weight of this. Kindly see the weight of this, This is the envelope. The envelope is the previous page. 72. Envelope is 72 and 73 is 10 grams. If I put this question to myself, I am an officer of court. I am telling your lordship, while I was sitting with Mr. Kothari, I told him, where have we specifically stated this? Apparently what we have done, I am indicating. We have stated it in our reply. We have stated it in this way, just to show your lordship, this was not a part of the records. This envelope is the only document that I have to demonstrate there are 10 gram.
In your reply before the assessing officer, you have said that you have.
No, not in the. I tell you, no, not there. But yes, I admit. I told I am an officer of court. I cannot try to hoodwink the court and get an order. I am indicating to, but it's a question of law. If there is a violation, it is inherent. Let us come back tomorrow. Kalke. Any time. Friday. Not Friday. Monday में जाइना. Monday
some difficulty. Tomorrow.
Monday then we can have.
আমি যাই না এখনো যাই না. Monday. Friday তো ওইটা ফিক্সড হয়ে গেল. পারবো না.
কালকে 10:30
সাড়ে 10টায় কেন ভাই? না 10:30 আমি